Sorry. Yes.
Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, February 25th, 2025. We have 11 bills on the docket, and we are joined by the distinguished Vice Chair from Triple E, Senator Kagan. We'll start off with Senate Bill 758. Senator Kagan, welcome.
Vice Chair, colleagues, Cheryl Kagan, very proud to be the Senator for Gaithersburg and Rockville. Homeowners associations, condos, govern our lives. They make our communities safe and accessible, and they oversee all the details that help when there's a resale or something. Most do it well, but some are not so great. And this bill, which was brought to me by actually a Gaithersburg council member, just establishes guardrails in 4 areas. Number one, it makes sure that there are fair elections. People on the current board shouldn't be running the elections because they themselves or their best friend or something could be candidates. 2, homeowners' rights. People should be able to disagree with the board without fear of retaliation or any interference. 3, there should be financial transparency. These HOA or condo associations are responsible for the dues that we pay, whether that's monthly or semi-annually or annually, and there have been instances where the condo documents, the financial documents, are not accessible to the owner or the resident, and they should be able to have access to that without excessive fees. And the last thing is there should be expanded oversight. The Attorney General should be able to intervene as needed. Simple bill. I didn't want to bring a lot of witnesses, but I hope you will move favorably, and I'm happy to take any questions.
Excellent. Thank you very much, Senator. Questions from the committee? Senator Sidnor.
Just one question for you.
Yeah.
I live in an HOA, and I know trying to get people to serve is extremely difficult. So I'm curious, what do you envision? How do you envision it playing out for those boards that have a hard time getting people involved when really sometimes it is just the board that's going to manage the elections because nobody else wants to get involved?
Sure. Thank you for the question. So this isn't about who can run or who can serve. It's who can oversee the counting of the ballots. It's really as basic as that. So if you're the president of your homeowners association and you're running for another term, and thank you for your willingness to serve, right? You shouldn't be the one gathering petitions, overseeing the election, or counting the ballots. So whether that's other folks or whether that's an outside entity, but there should just be the appearance and reality of transparency and fairness.
So would a nominate, if the board puts together a nominating commission, would that be sufficient?
I think if there's a nominating committee, but if there's a contested election, it's still the challenge of who's counting the votes. I think if we were counting the votes for our own elections, I think that wouldn't smell right. I don't think people would think that's a great idea. So in the same way, the incumbent board members for the homeowners association or condo association shouldn't be able to oversee and count the votes for their own elections.
Okay, thank you.
Thank you.
Thank you, Mr. Chair. And sorry I arrived late if this question has already been asked. So over the years, we've passed a lot of bills to impose requirements on condo associations, co-op associations, homeowners associations, so much so that I'm increasingly getting concerned that it's almost as if in order to have a condo, you have to have a full-time lawyer on staff in order to advise you about all the requirements. So why do you think this bill is necessary for us to pass as opposed to the condominium owners who, after all, control their own condominium, putting these requirements into their own homeowners association bylaws?
Thank you, Senator West. So I'm happy to chat with you offline on the 4 things that this bill does. But one of the challenges is that if there's a member of a community that disagrees with, let's say, the incumbent board, they're the ones who have to hire an attorney. They're the ones who can't get access to the financial documents or get unreasonable charges. So this is about transparency and fairness. This isn't about huge new burdens on any community. We're not looking to raise anybody's fees or costs. The fiscal note has zero. We just want to make sure that they are well run. And I should tell you, when I was in the House, I actually passed a few condo association and HOA bills. This does not include co-ops. We really just went HOA and condo associations, for whatever that's worth.
Who's your cross-file on this?
Delegate Marvin Holmes and I, and he's kind of the condo guy.
Yeah.
I think they're a smidge different, but but he said yes to cross-filing, and so we are looking forward to continuing to work with Delegate Holmes.
Thank you.
Thank you.
All right, further questions from the committee? All right, seeing none, thank you very much, Senator Kagan. Thank you.
Thank you. Quick and easy. Take care.
Thanks. All right, with that, that'll conclude the hearing for Senate Bill 758. We'll now move on to we'll go Senator Love.
Chair Smith, is it okay if I bring my panel up with me?
Yes, please.
Okay, thank you. So good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of JPR. I'm Gretchen Zekiel. I am Senator Sarah Love's Chief of Staff, and I am also a very dedicated dog parent who is here today to present SB 896, the Pet Policy Transparency Act, on behalf of the sponsor. So I started out by introducing myself as a devoted dog mom because I think for most of us who have pets, they're like family to us. And it would take extraordinary circumstances for us to leave them behind or to surrender them to a shelter. So I was really surprised when I learned that actually in Maryland, we have a growing crisis of the number of animals that are being surrendered to shelters, and particularly for dogs, large dogs of specific breeds. And the number one reason that is cited for this, for relinquishing animals to shelter, is housing-related issues. So it turns out that not only do we have a housing crisis, particularly affordable housing, but we also have a homeless pet crisis in Maryland as well. And the two are inextricably linked. SB 896 takes a very important first step in helping Marylanders who are looking for rental housing, particularly those residents who are among our most vulnerable, find pet-friendly housing that meets their needs. And before I tell you how, what I want to share with the committee is that the sponsors have met with a broad range of advocates, everyone from animal advocates to housing providers, other stakeholders, so that we could come up with something that would be a first step in terms of making some progress toward addressing this overwhelmingly important yet very complicated issues. So SB 896 does two things. First of all, SB 896 requires that landlords in rental properties and property managers post their pet policies up front from the get-go in virtual advertising, on their website, on rental search engines, and also with their application, as opposed to often when it happens late in the game with the lease that is about to be signed. It also creates consistency among pet policies so that those who are looking for rental properties can compare options. It looks for What are the breed restrictions? What are the number of animals? What is the weight limit? Vaccination requirements, pet fees, additional requirements. It sets forth this particular consistency. Before I go on to explain why this bill, it's relatively simple, is so important, I do want to mention that the now Humane World for Animals did conduct research that supported this hypothesis of the importance of having transparency in pet policies up front. And they're going to talk about that in a few minutes. But what I wanted to share really is just one story that was included in witness testimony from Lauren Lonnie, who is an animal and housing advocate. And here is what she included. After having been approved to sign a lease at a rental property and subsequently bringing her dog to meet the property manager said to the prospective tenant, "Oh, I mean, you're approved, but you have a pit bull. So, I mean, you get rid of the pit bull, you can move in." So prospective tenants, like this particular woman in the story that I just shared, can lose their security deposit. They can lose valuable time in terms of searching for rental housing in a competitive market. And a worst case scenario, they can end up losing their beloved pet. So what we need is to have this transparency at the start. More consistent, transparent, and accessible pet policies for all rental properties can ease the burden for renters. It can also make expectations clear for landlords, help keep pets and people together, which really is our main goal. So for these reasons, I request a favorable report on SB 896.
So we'll take questions at the end of the panel. So
Okay.
Yeah, thanks.
Absolutely.
Good afternoon, Mr. Chair, members of the committee. My name is Jennifer Bevan Dangle. I am here representing Humane World for Animals, formerly known as the Humane Society of the United States. As you've already heard, this is a really important next step in addressing the area where the housing crisis and the pet shelter crisis are overlapping, and the two are inextricably linked. The reason for transparency and the focus of this bill is twofold. First, we do want to thank the stakeholders who spent considerable time at the beginning of the session and before and previously with us and with the sponsors working out what an appropriate next step would be. And we want to, I think that's reflected in the very broad support you see in the witness, in the written testimony before you, which for the sake of the committee, we're not bringing all of them in to speak. But this really is a consensus step. It's a really important next step. And that's because when tenants are coming in to sign their leases, to find housing, as you've heard, they're often in a crisis situation. So if at the last minute their understanding of the rental agreement changes, it's often too late for them to pivot, too late for them to find somewhere else to go. And as was mentioned, it often means that they have to choose between that housing or abandoning their pet. There was research done, as was mentioned, and looking at about 400 listings on the affordable housing search, 67 or 17% said they accepted pets. But for 47% or nearly half of those, the prospective tenant had to call to get the full details of the pet policy. When someone's in crisis, when they're searching for housing, this is a very significant extra step for them to have to take when it's so simple and easy for the provider to have this information readily available at the front end of the process. So we thank the stakeholders, we thank the sponsors, and we urge a favorable report.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Katie Flory, and I am the Community Care and Advocacy Director with the Maryland SPCA in Baltimore City. I am also the treasurer for PAWS, which is the Professional Animal Welfare Society. And on top of that, I am a pet parent and a private landlord. And I really wanted to come and speak today because this bill is so incredibly important to all of us in the state of Maryland who work in the shelter field, but it's also important to me as a landlord. I want to be able to tell my tenants that they can have an animal. I want to be able to let people know that are looking for rental properties how important it is, and I want them to have a pet in my rental property. But on top of that, in the shelter world, there is not a day that goes by that we are not bringing in animal after animal because somebody wasn't able to find housing. This morning, I actually took a dog to WMAR. His name is Apollo. He's 5 years old. And the reason that he was surrendered is because his family had to move and was not able to find a place to take him. He is the best boy, well-trained, lives with cats, lives with dogs, lives with everyone, and he was not able to go with his family. We don't want to see that happening to other people in our community. And this is a very easy bill to help with transparency and to help the state of Maryland, who is looking for places to live, an easier way to find them. Oftentimes, it's hard when you're in that crisis situation to figure out where to go, where do I look to find pet-friendly housing? And even for people that work in this field and we're trying to help people find places to live, we can't always find it. So please, we urge you to provide a favorable report for SB 896. Thank you so much for your time.
Excellent. Thank you all very much. Questions from the committee? See Senator West.
Thank you, Mr. Chair. Maybe for the sponsor of the bill, could I ask you a question?
We have one more.
Oh, I'm sorry.
Oh, my apologies. You know what? Well, this is the sponsor panel, but let's have Ms. Radoff come up. Good to see you. Welcome. We'll have you provide your testimony, and then we'll open it up for questions.
Good afternoon. Can everybody hear me? Thank you, Chair Smith,
we can.
Mr. Waldstreicher, members of the Judicial Proceedings Committee. Thank you for the opportunity to testify virtually before you today in support of SB 896. My name is Lisa Radoff. I'm the president and chair of Maryland Votes for Animals. We strongly support this bill. We need it. We need this mechanism to ensure that renters understand the policies of their landlords and property owners regarding pets. You've heard a lot of compelling testimony from Senator Love and from Katie and from Jennifer Bevan-Dangle. A national study conducted by the ASPCA revealed that renters are more likely to rehome their pets for housing-related issues than for any other reason. As we know, pets are treasured members of our family. Having to rehome a pet can be traumatic for both the pet and the family members. Our shelters, as you have heard many times, are already over capacity. We recognize that there is a legitimate shortage of affordable housing and that this is an issue for that group of people with pets. This bill is a small but important step towards dealing with this issue. Thank you to Senator Love for her sponsorship of SB 896, and I urge a favorable report.
Excellent. Thank you very much, Ms. Radoff. Mr. Hill, would you like to come and testify, and then we'll open it up for questions.
Thank you, Mr. Chair, members of the committee. My name is Matt Hill. I'm an attorney with the Public Justice Center. We are favorable on the bill. Pets are a source of much contention for some of our clients who are renters, both in terms of contentions with the landlord and with their neighbors at times. And so we're supportive of any provisions that provide for more transparency from landlords in terms of what the fees are going to be or any restrictions around breed. That kind of transparency is always welcome and hopefully can avoid some of those contentions down the road. And I don't want to add, I don't have much to add to the excellent testimony you've already heard. So with that, we'll ask for a favorable report.
Thank you, Mr. Chair. First, Ms. Radoff, it's great to see you and your friend on the sofa behind you. I've been spending more time watching the friend than I spent watching you. So I guess for the sponsor of the bill, I do have a question. So I'm with you most of the way through this bill. Clearly, a landlord should be able to provide a link on the property's website to the property's pet policy. That should be simple to do. Similarly, in any information provided for a residential rental search engine, that should be simple to do. It also should be simple to provide a written copy to someone who applies to rent the property. Where I leave you, I think, is in the requirement that this information needs to be provided in any digital advertisement for the property. I've never heard of us trying to control what appears in people's commercial advertisements. And normally a commercial advertisement tries to sell the property. But I look at the pet policy and it covers breed and weight restrictions, required fees, including upfront fees, refundable pet deposits, monthly pet fees, any limit of the number of pets allowed in the unit, vaccination requirements, liability insurance, goes on and on and on. It sounds like this advertisement is going to be more about the pet policy than about trying to sell the property. Don't you see a problem in that? And would you have a problem if we deleted that provision from this bill and kept everything else here?
Well, thank you, Senator West. That is indeed a very good question. I would say that the advertisement itself wouldn't have to list all of that information. It would just have to list a way to get it, either through a direct link or through a bit.ly, some way to get that. And I would say that, and I turn to my experts as well for their input on this, I would say that when a landlord advertises a property, it would be beneficial for the landlord to be attracting potential or prospective tenants that are going to work out from the get-go, simply because in addition to time constraints for those looking for housing, the landlord has also gone down a path and taken time to, with a tenant who may at this point just end up leaving and, going elsewhere to find something. But we obviously would be happy to entertain any friendly amendments.
Sure. So would you be satisfied if the requirement was a digital advertisement would have to contain a link to the website on which the pet policy would be contained? So they just, you wouldn't
Yes, we would be.
You wouldn't have to summarize the pet policy in the advertisement, just
Right.
provide the link to the website.
Absolutely, we would be.
Thank you.
Further questions from the committee? I had to stop bringing my dog to the pond. The ducks kept eating him. Guess that's what I get for buying a purebred dog. Oof, terrible dad joke. Terrible dad joke. All right. Tried to lighten it up. I tried.
Chair, I would say that this has rounded out my experience. To have you add one of your special jokes to this has made my day. Thank you so much.
Special, that's a very charitable way of categorizing it.
Chair, I must say that was a very stale.
Stale joke. Oh.
Bada bing, bada boom. Okay.
Purebred dog, come on.
Anybody else have anything to add?
All right. With that, that'll conclude the hearing for Senate Bill 896. Thank you very much.
Thank you.
Excellent. All right, we'll now move on to Senator Watson, who's joined us with Senate Bill 817.
Good afternoon, Mr. Chairman and colleagues. I'm going to let my intern, Ms. Savannah Grooms, introduce this bill.
Good afternoon, Chair Smith, Chair Waldstreicher, and the JPR Committee. For the record, I'm Savannah Grooms, representing District 23 in Prince George's County, and today I'm presenting SB 817, which is the Common Ownership Communities Candidate or Proposition Signs Display Period. This bill is quite simple. SB 817 changes the law to allow common ownership communities, COCs, in Maryland to start displaying campaign signs 30 days before the early voting period for a primary election, general election, or vote on proposition, and 7 days out afterward. Current law does not include the early voting period. It only allows for political signs 30 days before the actual election. This bill will allow additional time for campaign or proposition signs to be displayed on COCs 30 days before early voting begins. This bill only covers campaign signs and private property and not in common areas in the COC, and it does not change any federal, state, or local laws. I ask for this committee's favorable report on SB 817.
Good job. Good job. Thank you, Savannah. Let me just add, Mr. Chairman, there is an amendment to this bill offered by the HOA United, and I consider it a friendly amendment. I'll be working with this committee to get this added because the bill as proposed requires an owner to remove a sign 7 days after a primary election and then repost it no sooner than 30 days before early voting for a general election. The intent is to ensure that signs could remain continuously posted before primary through the end of a general election, and I will amend the bill to make sure that that's supported because we all know how campaigns work. It doesn't stop until after the general. So with that, I'll entertain any questions, but I ask for a favorable support for this bill.
So thank you very much, Senator. Questions for Senator West?
Uh-oh.
Sorry, I hate to keep asking questions, but you had me until you offered the amendment. But there's a long gap between a primary, and the primaries typically in Maryland are in June, and the general isn't until November. So this bill would it be enabling, or would it require a homeowner association or condo association to allow the signs to remain up all the way through June, July, August, September, and October?
I know it sounds cumbersome. My intent would be to require them to leave them up. Just the same way that they cannot stop you even if they have a no solicitation sign on their door. They can't stop you from knocking on a door, talking about political positions, who's running for what, those types of things. This is a part of free speech, and I believe that in a campaign period, there should be full notification of who's running, and this is what we do.
I know in my campaigns, at great inconvenience, immediately after the primary, I removed all those signs, and then I put them up again in October. It was a royal pain in the neck, but I didn't want to inflict those signs on my constituents all the way through the summer and the fall. So anyway, thanks.
Thank you.
Thank you, Mr. Chair. So much like my good friend here from Baltimore County mentioned, that it's a pain to go back and do that. And as someone that's already announced that he's probably not going to ever have to deal with that again, I would say that those that may have to deal with that appreciate your thoughtfulness in bringing this forward and your staff for her wonderful presentation of the bill. So thank you for that. That was wonderfully done. And I look forward to moving the bill with the chairman's full support.
Thank you.
Thank you.
Thank you.
Kumbaya. All right. Further questions from the committee? All right. Thank you very much, Senator, and thank you very much.
Thank you, Mr. Chairman.
Excellent job. All right. With that, that'll conclude the hearing for Senate Bill 817. And we'll now move on. I think it's Senator Ellis is on his way for 728. All right, we'll hear from Senator Ellis with Senate Bill 728. Senator, welcome.
Thank you, Mr. Chair and Vice Chair. And just finished up another bill here in Budget and Tax, so give me 2 seconds to get my beer in here. Okay, thank you so much. Yeah, Chair Smith and Vice Chair Waldstreicher, members of the Judicial Proceedings Committee, good to be here. Senator Arthur Ellis from Charles County, here to present Senate Bill 728 as a Charles County senator. Yes, they are more than one. Senator Jackson is 27A, a small part of Charles County, and I'm 28. So this bill is a delegation bill. Both of us signed off on this legislation, which will require each member of a common ownership community governing body, board of directors, or officer or council of unit owners of a completed condominium unit to have training before they go as a director on a association board. Those of you who've have experience or lived in a common ownership unit or HOA, you know, we have great neighbors, well-meaning neighbors who volunteer to be on this board but don't have a clue about what they're getting into. And so that problem would be alleviated, we believe, if upon accepting a position on the board of directors that members go through a short training session on rules, rights, responsibility. And that is such a very short, straightforward bill. Committee members, I urge a favorable report on Senate Bill 728.
Excellent. Thank you very much, Senator. Questions from the committee? All right. Do we have a delegation letter?
I know we signed one this morning, and my staff is supposed to send it to the committee. Excellent. And so I'll make sure it gets here.
Okay, excellent. Thank you very much.
You're welcome, Mr. Chair.
Questions? All right, Senator, thank you very much. With that, that'll end the hearing for Senate Bill 728. We'll now move on to the Howard County Senators with Senate Bill 777. Okay, we'll now move on to Senator Henson with Senate Bill 856.
Thank you, Mr. Chairman. May I bring up my panel as well? Thank you. I believe I have joining me today Matt Hill from the Public Justice Center, Joseph Lovelace from Maryland Legal Aid, and Lisa Sorrow from Community Legal Services, and Wesley Stewart from Green and Healthy Homes Initiatives. Colleagues, I am here to present Senate Bill 856, the Maryland Tenant Mold Protection Act. This bill is a multi-year effort. It started with a work group that was adopted in 2023 that convened industry experts and also representatives from Maryland Department of Environment, Maryland Department of Housing and Community Development, Maryland Department of Health, and Maryland Department of General Services. They came together with industry experts as well to discuss mold as it occurs in rental housing. We know that this can be an insurmountable challenge for tenants. We know that mold remediation can be costly, too costly for tenants to afford, and it needs to be addressed systemically, which only the landlord has the power and capability to do. What the work group did was they put together 4 recommendations, which we've adopted most of those into the contents of this bill. Specifically, what the bill would do is require that the Maryland Department of Environment establish best practices for mold reduction and prevention and through a website, and that also they would distill it into a pamphlet that landlords would give to their tenants. And then would require that that pamphlet be updated regularly to make sure the information remains current. In addition to that, it would require that landlords within 45 days after receiving a notice perform a mold assessment and remediation. So the mold assessment is when the landlord has an opportunity to figure out what the proper corrective action is. So the bill isn't too prescriptive, but it does make sure that those reports result in something meaningful being done by way of action. And then additionally, it requires that properties be maintained in accordance with applicable federal, state, and local residential housing laws. If we are to adopt this bill, it would put Maryland in line with 15 other states and Washington, D.C., which have codified protections to prevent the occurrence of mold. And some of those states have much more humid climates than the state of Maryland. Florida, Louisiana, North Carolina, and Texas are among the states that have addressed this issue. So I believe, colleagues, that if those states are able to tackle mold growth, then the state of Maryland certainly is able to align itself with those 15 other states and Washington, D.C., and make sure that we are protecting our renters. With that, Mr. Chairman, I will turn it over to my panel.
Good afternoon, Chairman, members of the committee. My name is Lisa Sorrow, and I'm here today on behalf of Community Legal Services in strong support of Senate Bill HB 856. I would like to thank the sponsor for her tenacity in bringing this bill back year after year. It's so important. We work with renters often who are experiencing mold conditions. This bill will provide a clear standard that they can apply to the conditions that they're living in, and that also their landlords can use as a baseline. We see tenants try to use the rent escrow statute to protect themselves from mold conditions. It's very hard for tenants to prevail in those rent escrow actions without a standard baseline for what is okay and what isn't okay. You may know rent escrow is the type of action that's filed where a tenant can withhold rent, they pay it into court, while the court looks at whether the conditions they're living in require landlord intervention. The court has to make a determination if the conditions are healthy or unhealthy before they can accept that case as a legitimate rent escrow case. Without standards, tenants are not able to consistently use the rent escrow statute to their benefit. So we see, even within courts, from judge to judge, we see different decisions happening, and certainly from jurisdiction to jurisdiction. This bill would level the playing field so everybody is working from the same basic facts. For that purpose, we would urge a favorable report on this bill. And again, I'd like to thank the sponsor for bringing it back.
Good afternoon, members of the committee. Joseph Lovelace with Maryland Legal Aid. Also proudly here to support Senate Bill 856. Like Ms. Sorrow just said, the rent escrow statute exists. If you read it and you're an open-minded individual, you might think, well, this should cover mold. But the reality is that not all of our judges, unfortunately, are open-minded. They see an illustrative list of examples of things that should be covered, like fire hazards, water damage, those sorts of things, and think that the illustrative list is just the list, and that's it. And if you're outside the list, you're not covered. What this bill does is provide a mechanism for tenants living in mold-affected property to request that action be taken and set some parameters for what action should be taken through the work that will come out of MDE. I'm here to say, having worked with numerous clients, especially of late in the Washington County area. Mold is a hazard that exists all over this state. I've done cases all over this state. I've met with tenants all over this state, and I can say there's not a county with rental housing that doesn't have some mold-affected rental housing. And the access to a remedy is hard coming at best, in the best of circumstances. I had a client, we just did a rent escrow, where he testified in open court that he had to sleep with a mask on because the mold was so bad, but he was a man of limited means. Maryland Legal Aid doesn't have clients with deep pockets. He couldn't simply move somewhere else. And for months, he waited for his landlord to take action, and they took none. I have another client. He lives in Hancock. He notified his landlord in October of a mold hazard, and he did this through his portal. We could see in his portal in December, the landlord noted the request. When I met him in February, nothing had been done. This bill will hopefully make sure that something gets done. Thank you.
Good afternoon again, Mr. Chair, Mr. Vice Chair, members of the committee, Matt Hill, Public Justice Center. And we see a significant number of clients who have mold in their units and do not know how to address it, as my other two colleagues said. Just to give you a little bit about one client, she lived with her son in one of the Baltimore apartment buildings that used to be owned by Westminster Management and Jared Kushner. Those were sold to another owner, and she had terrible bright green mold growing on multiple walls in her unit. She would periodically wipe it off herself with bleach, but it would always come back because you weren't addressing the cause of the mold. She complained repeatedly to the landlord, but nothing was done. She had a son living with her in the unit, and the son had asthma. That is not a surprise. This is not just an issue of things that look bad and smell bad. This is a real public health crisis. So we helped her to call code enforcement, got a city code inspector out to the property. It's not just that the court doesn't have any guidance on how to deal with mold. The code inspectors don't have any guidance on how to deal with mold. Mold is not a code violation in most jurisdictions in Maryland. So this is a major issue for code enforcement as well. The code enforcement did write her up, and they often do cite the mold, but they'll cite it under something else since mold itself is not a code violation. Anyway, our client wanted to move, and so we were able to help her to avoid an eviction while she was able to move out of the property. But this is just one example, and again, there's no clear standard. It's all ad hoc, and so this bill is extremely important to set the standards for what is a mold hazard, right? What constitutes an assessment of that mold, and then what is real remediation, and not just paying the guy down on the street to throw some bleach on it, which is what we see a lot. So this is an extremely important bill, and we urge the city, the General Assembly for a favorable report. Thank you.
All right. Thank you all very much. All right. Questions from the committee. Senator West.
Thank you, Mr. Chair. I think this is a fine bill. Mold is clearly a problem, and shame on landlords that allowed it to continue. However, I want to read a paragraph from the opposition sent by the Maryland Realtors and ask, I guess, the sponsor of the bill to respond to it. It says, the Realtors believe that giving a landlord 45 days to complete an assessment and remediation of the property may not be enough time, particularly in a single-family rental property. It's not uncommon for tenants in these properties to turn off a dehumidifier in a basement because of energy costs or noise. However, for most basements, the dehumidifier protects both the tenant and property from mold growth. If a situation goes unchecked in a property like this and wallboard must be removed and basements treated, which has happened, it can take longer than 45 days to remedy the mold. This example demonstrates the prevention of mold in every unit is not just a landlord's responsibility. Tenants also bear responsibility to ensure protection from mold growth. So I'm looking at the bill that you filed, and the bill requires, it says the tenant shall perform a mold assessment and mold remediation within 45 days. Would you be willing to accept an amendment to the bill which would require the mold assessment to be provided within 45 days and the remediation to be done within a reasonable period of time, within 45 days if possible?
Yes, I would consider that friendly.
Thank you.
Thank you.
All right, further questions from the committee? I'll say thank you to the sponsor for bringing the bill forward.
Thank you, Mr.
Looking forward to
Chairman.
working
Thank
on
you,
this.
colleagues.
All right, thank you very much. Thank you all. All right, so we'll now move on to, we have one more witness here. Also want to just acknowledge that we have Senator Kagan joining us as the bill is cross-assigned to Triple E. So we'll now hear from Mr. Greenfield.
Thank you, Mr. Chairman. Excuse me, Mr. Vice Chairman, members of the committee. Aaron Greenfield here on behalf of the Maryland Multi-Housing Association. We are favorable with amendments. You have our written testimony. We support the intent of the bill, particularly its focus on resident education regarding mold prevention, and certainly thank the sponsor for her many years of steadfast advocacy on this issue. The mold work group recognized the importance of resident awareness, recommending the development of a centralized website and distribution of educational pamphlets to tenants in alignment with the bill's objectives. However, we have two very specific amendments. The first one is requiring landlords to redistribute the pamphlet every 2 years, along with obtaining a signed acknowledgement, creates unnecessary administrative burdens. The mold work group specifically supported providing educational materials to tenants, but does not suggest repeated distribution requirements beyond the initial lease signing. We recommend striking the biennial requirement on page 4, line 15. And then a little bit different take on Senator West's question. Our second amendment, we think it's reasonable that a mold assessment is done within 45 days. However, a little bit more to the Senator West's point, this bill triggers an automatic mold remediation. What happens if the mold assessment doesn't indicate it's mold? This bill would require a mold remediation. So we would suggest that you strike the mold remediation language, and perhaps we're open to another amendment that in some way includes a mold remediation if it's found that mold is determined at the mold assessment stage. And for those reasons, we recommend a favorable with amendments report.
Excellent, thank you very much. Well, we'll be working on this bill later this week, so we'll engage with the sponsor, and I know the discussions will continue. Further questions from the committee for Mr. Greenfield? Okay, seeing none, thank you very much. All right, with that, that'll conclude the hearing for Senate Bill 856. We'll now move on to Senator Lamb, who's representing the Howard County Senators. We'll hear Senate Bill 777.
All right, thank you. Good afternoon, Chair Smith, members of the committee. Here to be able to introduce Senate Bill 777. This is on behalf of the Howard County delegation, and this is a delegation bill. And for the record, Clarence Lamb, Senator in District 12. This bill addresses significant concerns raised by a bill from 2022 requiring HOAs and condo associations to have fully funded reserves. As you have likely heard from your own constituents, as has many folks across the state, this 2022 law has resulted in significant fee increases for HOA and condo association residents, which has made housing even more challenging for many folks. This bill will give HOAs and condo associations a longer runway to fund their reserves, limit the funding requirement to items that cost more than $10,000 to replace, and also require reserve studies to consider alternative funding mechanisms. There is a statewide bill seeking to make very similar changes to this bill. This is a local bill, and the delegation would be happy to defer to that bill if it is the committee's preference to enact the statewide provisions. But we wanted to have at least a local bill in place in case the statewide bill runs out of time or does not pass. Prior to 2022, this was a local issue with only Prince George's and Montgomery County HOAs and condo associations being required to have fully funded studies. And so this is a local bill for Howard County, and ask the committee for consideration of a favorable report.
All right, seeing none, thank you.
Thank you.
Cold bench today. All right. We'll now move, that'll conclude the hearing for Senate Bill 777. We'll now move on to Senator Muse with Senate. Oh, I'm sorry. Pardon me. We're not over with the bill yet. Is Scott Silverman here? And Robin McGoonan? Both signed up in opposition, and then we'll switch on to the next bill. Apologies for that.
Good afternoon, Chairman Smith, Vice Chair Waldstreicher, and members of the committee. I am here on behalf of the Maryland Legislative Action Committee of the Community Associations Institute to oppose Bill 777 as written. The reason being that, as Senator Lamb pointed out when he introduced the bill, there is a comprehensive statewide bill, HB 292, cross-filed with Senate Bill 63. I know Senator West is specifically aware of this because he was kind enough to participate with us on the markup of SB 63, and we were working with Delegate Holmes, who is championing HB 292, which we believe and fully support represents the best middle ground for revising the existing statewide mandate for reserve bills and reserve bill funding. This bill in particular, in our opinion, it does not make sense to limit the inclusion of items in a reserve study to those costing more than $10,000 because there is no exclusion for associations that are relatively small, and they could easily have capital components that cost less than $10,000 to replace. In addition, the extension of the ramp-up period to reach full funding from 3 years to 10 years, in our opinion, it goes way too far. Delegate Holmes and Senator Mew's bills make a good compromise at 5 years, and that is what we fully support. We believe 10 years would significantly undermine the mandate. Thank you.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the JPR. My name is Robin Manoogian. I'm a 17-year member of CAI's Maryland Legislative Action Committee. I'm also a 30-year insurance agent, and I was a part of the task force that CAI put together after the collapse of the Surfside Towers in Miami. You know, one of the things that we seem to forget about these reserve studies is what they were created for. CAI instinctively knew that rescuing associations from failing to reserve properly was paramount. And ahead of its time, PG County came up with their own reserve study law, and then Montgomery County adopted theirs in 2021. Maryland passed a statewide reserve law in 2022. Current law requires all associations to obtain a reserve study every 5 years. The associations have 3 years to fund that from the time that they complete the annual study. Since the law has passed, however, Maryland LAC has witnessed an introduction of any number of bills that would seek to gut the whole purpose of these reserve studies and carve out exemptions for associations. So we understand the financial burden that is entailed in funding. But adhering to a reserve study to save for future expenses, and we know that that's difficult, but these businesses, and they are businesses, they have to fund for their future, not just now. And if we take away or dilute the law that's on the books right now, stretch it out for 10 years or any number of years, it simply kicks the can down the road, and we're trying to avert another catastrophe or loss of life. Thank you.
Either one of you, I guess, could answer this. I'm a little confused at the difference between a statewide bill on the one hand and a Howard County bill on the other. If we have, I don't know whether it's the policy of the General Assembly in the past, but if we have a statewide bill, do we allow counties to carve themselves out of the statewide legislation and adopt legislation which is either more onerous or less onerous than a statewide bill? I'm not sure I've run into that before. Yeah. How would you address the issue?
Actually, Senator West, that particular question specifically is somewhat above my pay grade, but I will remind the committee that that process actually, as Ms. Manoogian pointed out, actually worked in reverse with the reserve legislation, because it was first Prince George's, then Montgomery jumped on the bandwagon, and then we eventually got Delegate Holmes' support to expand it statewide. We believe that based upon Senator Lamb's testimony earlier, we believe that the legislation, this particular bill, was introduced in case the statewide fix, if you will, the one that we marked up, doesn't pass, that they would have some relief. But in my opinion, this is one of 5 competing bills with Delegate Holmes and Senator Muse cross-filed comprehensive bills. And it's our opinion that all 5 of these should go by the wayside so that his bill will have a clear path to passage, because the passage of any of the competing bills, they either do too little or they go too far to dilute the mandate. It's our position that they will create confusion among the lay volunteers that are on boards of directors throughout the state who are trying to comply with the mandate in good faith, and they won't be able to have clear guidance from the legislature as to what they should do.
That's my concern. Most of the people involved in these homeowners associations or condo associations, they're not lawyers.
Correct.
They're just residents. And to hit them with state legislation as well as local legislation, county bills, and then possibly local legislation from their local jurisdictions is going to cause an incredible amount of confusion.
Yeah, but we do have that challenge in Montgomery County, which is, as you know, a very active local legislative body, and there are many instances in which Montgomery County has enacted local code provisions which bump up against the state law and do require attorney guidance in order to pilot the association through to make sure that it's complying with both.
So I guess my last question is, do you think it would make sense if we passed the statewide legislation to include a provision in it that preempts inconsistent county legislation, so there should just be one bill, one system which would apply statewide?
I think we would definitely be in support of that, and in particular to allow the ramp-up period to be extended from 3 years to 5 years, because that's where we're hearing the greatest amount of pushback from our associations. Once they spend the money on the reserve studies, which are not inexpensive, and they receive the recommendations, it can be onerous for them to immediately bump up their assessments to the level necessary to fully fund in the first year. The statute gives them 3 years, but many of them, the older ones, are saying, and the smaller ones, are saying that 5 years is much more reasonable.
Great. Thank you for your answers.
Thank you.
All right, further questions from the committee? All right, seeing none, thank you both very much. Thank you. All right, with that, that'll conclude the hearing for Senate Bill 777. We'll now move on to Senator Muse with Senate Bill 866.
Good afternoon, Chairman Smith, Vice Chair, and members of the Senate Judicial Proceedings Committee. For the record, I'm Jasmine Hall, Chief of Staff for Senator C. Anthony Muse, representing the 26th Legislative District. I'm here today to urge your support for Senate Bill 866, which establishes a common ownership community ombudsman unit within the Division of Consumer Protection in the Office of the Attorney General. This bill is needed because Maryland has hundreds of thousands of residents living in common ownership communities, COCs, including homeowners associations, condominiums, and housing co-ops. These communities have rules and governing bodies, but when disputes arise, homeowners often find themselves with no clear place to turn for help. In fact, this has been an issue for over 2 decades. In 2006, the Task Force on Common Ownership Communities reported that ombuds offices should be set up at the county or regional level to function as a first point of contact to receive and resolve complaints. So this is not a new issue, but it is still an unresolved issue. Right now, Maryland law provides basic regulations for these communities, but enforcement is limited. Homeowners with questions or disputes have very few options. One option available is the Attorney General's office. They offer mediation, but only if both parties agree that the AG's office cannot provide legal advice, and the AG's office cannot provide legal advice. Another option available is some counties like Montgomery and Prince George's is local commissions, but their structures vary and does not fully address homeowners' needs. Therefore, SB 866 creates an ombudsman unit to serve as a central resource for constituents who need help navigating the rules of their common ownership community. The unit will answer questions and help residents understand their rights, receive and respond to complaints about HOA, condo, and co-op governance, reduce costly legal disputes by offering guidance and information, and publish resources on state and federal laws related to common ownership communities. In addition to the Ombudsman Unit, SB 866 also requires HOAs, condo associations, and co-ops to file copies of their governing documents with the Department of Housing and Community Development, DHCD. Directs the Department of Housing and Community Development to create and maintain a public database of those documents so homeowners can easily access bylaws, rules, and amendments. And it gives local governments the power to establish commissions to assist residents and provide mediation and dispute resolution services. And yes, the Senator recognizes that this bill has a fiscal impact, and he is working with the House sponsor and the Department of Housing and Community Development's willingness to explore cost-saving solutions such as volunteer attorneys who can provide guidance and grant-funded paralegal positions to support the Ombudsman Unit. Additionally, we are aware of the opposition letter from the Maryland Judiciary, and we are working closely with the House sponsor and the Governor's Office, Department of Housing and Community Development to address their concerns. In closing, this bill is not a mandate. It only establishes the Ombudsman Unit and ensures homeowners have a place to turn for help. Maryland residents deserve transparency, accountability, and support when dealing with their common ownership communities. Therefore, on behalf of Senator Muse, he respectfully urges a favorable report for Senate Bill 866. Thank you.
Thank you very much. All right, so you've got two witnesses signed up in favor. We have Jenny Hyatt and then Ginny Polhouse. Come on up, and then we'll turn it over to the committee for questions.
Good afternoon. My name is Jean Hyatt, and I'm simply an owner and a resident in condo community in Baltimore City. I'm for this bill because having spent the past few months trying to navigate and understand the legislative process in order to get some other things done, I think an ombudsman, any liaison between the community and the government or other agencies has to be helpful. It's almost impossible to over-communicate. So if this would do that, I'm for that. I have to admit the other part of the bill on the local commission, not so much for, because I think a lot of us, and I speak for many of my friends and neighbors, we're kind of in regulation fatigue at this point. It's kind of like a barrage of a bill fell and a barrage of bills have come at us, and it's getting to be a little much. So I'm not sure a local commission, which would add one more layer of regulation, would be a good thing. I don't think, maybe I misread, I don't think it's spelled out in the bill exactly what this would do, but so I'm for the ombudsman as a liaison, but not really for the local commission because we don't need more regulation at this point. Thank you very much.
Thank you, Chairman and Vice Chairman. I'm Jeannie Polhouse. I'm a condo owner in Baltimore City. I'm very ambivalent about this bill. Again, ever since the catastrophe in Florida, we have been lambasted with one bill after another this year. Our condo fees have gone through the roof. We've had special assessments, and nobody is really clear on what these bills state. The original House Bill 107 is so vague that we've had attorneys look at it and nobody can come up with the same definition of what that bill means. I think the idea of an ombudsman sounds very good, but to add another layer of administration or regulations on condo associations is absolutely unfair. It's hard enough now to get people to even serve on a board. I serve on my board, and I'm getting ready to resign because I'm just getting so frustrated with all of these regulations. I'm an individual. I'm not a lawyer. I'm not a business person in charge of an association. We are a community. We only have 66 units. We're a small community, and we're like a family, and we take care of it, and our community is in very, very good shape. And all of the problems, the few problems that we've had, we've been able to solve between the board and the homeowner. So I have questions about this bill. I'm for it on one hand, but against it on the other. So that's my testimony. Thank you.
Excellent. Thank you very much. Good to see you again. Questions from the committee? Seeing none, thank you very much. With that, that'll conclude the hearing for Senate Bill 866. We'll now move on to Senate Bill 927.
For some reason, they stepped out. He went.
Oh, okay, no worries.
I can just start. Sorry, Alan. All right.
All right, good afternoon, everyone. Senator Smith here to introduce Senate Bill 927. As we've had several discussions on housing or the affordable housing crisis in Maryland, we had a 4-hour-long briefing. We've got, I think, by my count, at least 12 bills dealing with housing, which we're going to continue those discussions this Thursday for rental housing, but also the development of stable, affordable housing to purchase and to own, and also the conditions and terms and conditions of those agreements. So Senate Bill 927 deals with limited equity housing cooperatives, which is just a fascinating issue that I delved into, brought to me by constituents and then also my cross-file delegate, Lorik Charkoudian. As you heard earlier this year, we are facing an affordability crisis in Maryland and throughout the nation. Today, housing affordability is a significant barrier for Marylanders, as 52% of renters are cost burdened, which means they're spending more than 1/3 of their income on rent. So too is the same for home ownership, or the opportunity for home ownership. That prospect is even more distant today than it has been in the last decade. Today, Maryland ranks 7th in high cost of living in the United States, and its impact, the lack of affordable housing, both to rent but also to own, is impacting our workforce as well. 44% of young renters are considering leaving the state due to housing costs. 66% of Marylanders believe that there is not enough low-income or moderate-income housing, and 82% of Marylanders believe that buying a home in Maryland is too expensive. And so the limited equity cooperatives offer us, I think, an innovative way to increase affordable housing stock and to unlock home ownership opportunities for Marylanders. Now, what this essentially allows us to do is to create this new mechanism where you have a non-stock corporation that can apply to SSTAT to become a limited equity cooperative. You get a blanket loan, you get a loan, you mortgage it, you leverage it. Those folks get together, they pool their resources together, but then they have a cap on the equity that they can earn or accrue in this interest for the property, meaning that over the course of time, the property interest actually maintains its stability in terms of cost and affordability. So it's an interesting mechanism that's worked across the nation and has unlocked opportunity for, again, low and moderate income individuals in our state. A limited equity cooperative, or an LEC, is also a home ownership model in which residents, they again purchase a share, not in the development, and they commit not to resell, or they lock that resale price in. So again, the equity that they have is locked in. It's capped in a sense. So when this LEC is created, the initial affordability is usually achieved through some sort of a government assistance. And in this bill, it calls for tax abatements, and then also for other financial incentives that the government can provide, that the state can also provide. There are also mechanisms for the relocation of people, that when you're moving from a non-stock to this LEHC, for the cost of, if someone doesn't want to participate, there are costs associated with that that the bill calls for, provides for those moving costs. There are also again, interests created for how the county or how the state could provide for financial incentives. Again, like I talked about, a 5-year tax abatement if this LEHC is created. So with that, the bill, again, very simply provides for a process for a non-stock corporation in which its members are owners rather than shareholders to convert to a limited equity housing cooperative. They have to do this by an affirmative majority vote of the board, or voting members is required to adopt the resolution as a non-stock corporation to apply for the LEHC or for the LEC. The members have to purchase, again, interest and not actual ownership interest. So with that, I would ask for a favorable report and turn it over to my panelists, who will speak to some of their personal experiences in creating some of these mechanisms. I think this is a unique way to unlock opportunities for affordable housing in Maryland, and ask for a favorable report. All right, I'll turn it.
Good afternoon, Chair Smith. Oh, okay. All right. Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the Judicial Proceedings Committee. My name is Judy Tribal, and I'm the Secretary of the Leland Tenant Association. I'm here to speak in favor of SB 0927. The Leland Tenant Association is a group of neighbors committed to nurturing the sustainability of our larger community, keeping our homes safe and affordable, and supporting each other's well-being. In 2021, our landlord put our building at 112 Lee Avenue in Tacoma Park up for sale, which threatened to displace all of the 15 low-income households living there. In October of 2022, the Leland Tenant Association utilized Tacoma Park's tenant opportunity to purchase law to successfully acquire the property. The LTA's intention has always been to convert the building to a limited equity co-op, ensuring it would remain affordable and owned by the residents in perpetuity. Although more than 90 limited equity co-ops thrive in the District of Columbia, there are none in the state of Maryland. We soon learned the reason why. The existing state laws make the creation of a limited equity co-op confusing, expensive, and time-consuming. SB 0927 would help simplify the process and allow more tenant associations to follow our lead. This bill, were it to become law, would create another tool to stem the growing housing crisis within the state of Maryland. I urge a favorable report on SB 0927. Thank you.
Mr. Norkett, I neglected to mention much. No, but I did neglect to mention there is an amendment in the packet which is aimed at addressing some of the fiscal concerns associated with the establishment of the LEHCs. So initially, the burden of receiving the paperwork for the establishment for these for this organization, STAT said that it was going to be cost burdensome to accept all of those applications. So this amendment reverts back and says that the organization has to maintain those documents instead of voicing that responsibility upon SDAT. So the amendment's in the packet for your consideration. We believe that will assuage most of the concerns that were brought forth by SDAT.
Thank you, Mr. Handel.
Good afternoon, members of the Judicial Proceedings Committee. My name is Claudia Wilson-Randall. I'm the Executive Director of the Community Development Network of Maryland, and our mission is to promote, strengthen, and advocate for the community development sector throughout Maryland's urban, suburban, and rural communities. CDN envisions a thriving Maryland neighborhoods where people of all incomes have opportunities for themselves and for their families. I'm here today to speak in favor of Senate Bill 927. You have my written testimony, but I just want to make a few key points. Currently, there are books on the law in Maryland that say that residents can form limited equity co-ops, but the current statute is simply unworkable. Housing is an urgent priority for economic growth, and given the health, education, and cost implications of our present time, families living in with widespread housing instability are something that we need to urgently address throughout the state. As the senator said in his opening remarks, that we have a critical challenge. We need about 130,000 affordable housing units in the state in order for us to close the gap. Through limited equity co-op model, the buildings are preserved as community assets for the long term. Limited equity co-ops projects benefits continue well beyond their first residence. Households can build some personal equity while paying an affordable monthly maintenance fee and while stewarding their own affordable housing. When a family moves out, they sell an apartment to a new income-eligible household, thereby creating true, lasting, affordable, shared equity and community wealth. This model not only fosters diversity, but keeps families and generations within the fabric of a community. Thank you so much, and I hope that we will have a favorable report on Senate Bill 927.
Thank you very much. Any questions? All right, that concludes the hearing. Is Mr. Dugan here? Okay.
Dear Chair Smith, Vice Chair Waldstreicher, and members of the Judicial Proceedings Committee, I, as a representative of Mikasa, Inc., a 501c3 nonprofit affordable housing developer, I urge favorable passing of SB 927. Mikasa, Inc., we've been working in the affordable housing realm here in the DC, Maryland, Virginia area since 1992. We secure funding to develop affordable rental units, single-family homes, and limited equity cooperatives. I program manager, and I work with tenant purchase and technical assistance, specifically with limited equity cooperatives. And I think it's really important to carve out a legal pathway for limited equity cooperatives in the state of Maryland, as they are very distinct from a traditional market rate cooperative or a condo association or single-family home or traditional renter, landlord, tenant situation. And so I think that two of the main components that a limited equity cooperative can do, it can establish a clear pathway for anti-displacement so that residents can stay in place and then convert into an accessible home ownership model. That is what the limited equity cooperative allows. And then perpetually to be able to provide affordable and attainable membership shares so that the housing accommodation and home ownership opportunity remains affordable for future generations, for future residents. I'm more than happy to answer questions specific to limited equity cooperatives. Again, Mikasa, we work with developing and supporting limited equity cooperatives in DC, and we're really excited for working with the Leland Tenant Association and their pursuit of this homeownership model, and we're excited for the opportunity to create a pathway for future tenant associations to follow that path. Thank you.
Thank you very much. Seeing that there are no questions from the panel, that concludes the hearing on Senate Bill 927. Next, we'll have Senator Jennings presenting Senate Bill 787.
Thank you, Mr. Chairman. All right, thank you, Mr. Chairman. Distinguished members of the committee, Senator Fulton, Senator Jennings on behalf of Senate Bill 787. All right, I'm here today on this issue. This was a bill that was passed several years ago that I brought back, we're trying to correct. It's come to me from several of my constituents that are struggling with the impact from the bill we passed several years ago, which was House Bill 107. That was from 2022. That bill was following the tragedy of the Champlain Tower South collapse in Surfside, Florida, that many of us remember. While well-intended, House Bill 107 imposed overly aggressive timelines and unrealistic reserve funding requirements on HOAs, condominiums, and cooperative housing associations. We've kind of realized that now. That's why we're here with this bill. I know there's been some other ones introduced. I don't care whose bill passes. We just need to kind of fix it to kind of take some of the burden off of our constituents. Senate Bill 787 preserves the core safety measures of House Bill 107 while introducing much-needed flexibility in financial planning. This bill updates reserve study requirements and funding obligations to establish a more balanced approach to long-term maintenance planning. And I'll kind of lay out here some of the things that this bill does. One, it extends the reserve study intervals, which increases the timeline for the required reserve studies from 5 years to 10 years, giving associations more time for financial planning and reducing the burden on residents. Two, it targets applicability. This bill specifically mentions additional requirements for cooperative housing cooperations, HOAs, and condominiums with 4 or more stories or 4 or more single-family units. It does not exclude condo associations or single-family units with 4 levels or less. This bill keeps the requirements for these buildings regarding the repairs and replacements to the structure, integrity, and safety of the original bill as it was intended. It deals with parking lots, sidewalks, swimming pools, et cetera, would fall under the structure of the original bill. Refined reserve study requirements, limited mandates, repair replacement costs to those exceeding $10,000, ensuring a more realistic assessment of necessary reserves. So since I had this bill drafted, I have had some industry come to me, some constituents again. We've come up with some amendments which we have introduced. So there are 3 amendments that are, hopefully they've been introduced, they're sitting on your desk or on your computer. And those 3 are: 1, repair cost deduction, which any completed repair or replacement listed in the reserve study can be deducted from the required reserve amount. This will ensure associations do not obligate to maintain excess funds and are deemed fully funded after the repair or replacement is deducted. 2 is water and utility line inclusion, which mandates that water and utility lines within association property be included in the reserve study, ensuring comprehensive infrastructure planning. And 3, involvement of licensed professionals. This amendment removes the provision of allowing licensed professionals to conduct the reserve study, but permits licensed electricians, plumbers, and contractors to provide updated cost estimates within their expertise, ensuring more accurate and reasonable reserve fundings. The reason I bring that in, an example from one of my constituents, they were told by reserve funding specialists that they needed $65,000 for the new roof, whereas a licensed roofer who would come in to look at it gave them a quote of $35,000 for the same roof with a 30-year warranty. And by allowing a more qualified professional to assess the repair, we can prevent inflated, unrealistic costs for these reserve funds. Again, this bill, I'm not trying to take away from the original bill, the intent of the original bill. We're just trying to lessen the burden on the impact for our constituents. Again, I know many of you have gotten calls. We're just trying to make sure that we fulfill the original intent, but take the pressure off of these communities because they cannot meet these obligations. So with that, I ask for favorable consideration on this bill with these amendments, Mr. Chair.
Thank you very much. Any questions for the sponsor? Thank you very much. We have Ms. Hyatt, Ms. Polhas, Carol Jenkins.
Here we are again. Chairman Smith, committee members, thank you for allowing me to testify on behalf of Senate Bill 787. Several condo owners and myself have been meeting with quite a few delegates and senators regarding a revision to House Bill 107.
For the record.
Senator Jennings is the only one who has had his chief of staff.
Could you give your name just for the record?
I'm sorry?
Your name?
Oh, I'm sorry. My name is Jeannie Polhouse. I've been up here several times. I thought you knew that. Anyway, Senator Jennings is the only one who has had his chief of staff meet with us and listen to our concerns. Apparently, the Assistant Attorney General responded unfavorably to this bill, but she did not see the amended bill that should resolve her concerns. First of all, this bill does not exclude associations with 4 or less levels from requiring a reserve study. It does, however, state that only structural, electrical, and plumbing issues be included in the study. Secondly, it does not state that a reserve study can be done by a licensed electrician, plumber, or contractor. It does state that if an association disputes an estimated item on the reserve study, that they can obtain another estimate from a licensed contractor. Thirdly, requiring a reserve study every 10 years instead of 5 years does not change the validity of the reserve study. These studies can spread the estimated repairs and/or replacements over 5 years or 10 years. The estimates are given per the lifespan of a particular component. Reserve studies cost between $5,000 and $7,000 on average. To revise a reserve study, the cost is between $1,500 and $2,500. I wholeheartedly endorse this legislation, and I'm grateful, so grateful to Senator Jennings for his willingness to listen to us and act on our concerns as we are living this bill. Thank you.
Good afternoon. My name is Carol Jenkins. I've served for 8 years on the board of my condo association in Baltimore City, and I thank you, Mr. Chairman and Vice Chairman, for this opportunity to speak. This Senate Bill 787 takes a far more realistic view of the law now in place governing reserve funds for condominiums in Maryland. By establishing that the cost of repairs or replacements of a common element during the year be deducted from the next annual proposed budget and deemed fully funded, this bill reduces the extraordinary financial burden placed on condominiums by the law defined by HB 107. It also clearly defines fully funded. By specifying that water and utility lines be identified in reserve study, this bill removes important exclusions that have been in place under the current law under the assumption that utility companies pay for repairs on common areas of a condominium association. This is usually not the case. By extending the time between mandatory reserve studies, the costs of evaluating property over time are reduced by this bill. I would add that when we had, yet again, recently another reserve study, that takes us 30 to 40 years into the future as to planning our needs. Therefore, and enlarging the space between reserve studies, one is still looking to far future and planning accordingly. By allowing updated assessments to be made by licensed contractors, electricians, or plumbers, this bill provides real-time market pricing and increases cost effectiveness. This Bill 787 strikes a far better balance between financial responsibility and flexibility. It will empower property managers and board members to focus on long-term maintenance. I ask this committee for favorable report in support of HB 787. Thank you.
Hello again. My name is Jean Hyatt. Thank you to the committee for the opportunity to speak. I am an owner, have lived in the condo for about 30 years, just an ordinary citizen, not a lobbyist, not an expert. I'm changing my testimony a little bit because of hearing some other things. It's a little frustrating to be, to have these large financial burdens suddenly in the past 2 years imposed on you, and you hear experts who do not live in the condos and don't live this law saying how we should have these burdens put on us for our protection. I want to say that there's a big push toward affordability, a noble goal, but the law, H. Bill 107, very well intended, noble goal, has had unforeseen circumstances, and one of these is to make it unaffordable to live in condos. To give you just a brief, and this is not because so much work needs to be done. I think, hearing from most, that they've done this work. What it is the way the bill has written, the lack of clarity and definitions, the one-size-fits-all approach, and not discretion given to boards to how to use money. I want to give you an idea of what this is. My condo fees that were always raised every year have now gone up 30% in 2 years. On a fixed income, a retired school teacher, that's a lot of money to come up with $200 to $300 more a month. And it's not like a credit card you can pay off. On addition to special assessments of many thousand, people next door, 20,000, 40,000. Who can afford this? So I think this bill is a great bill because it brings some reality to a very idealistic bill. Again, well-intended, but it needs the amendments. I do more than hope. I pray that you will respond favorably to this bill. Thank you.
Thank you very much. Are there any questions? Seeing no questions, we have David Marks, who's mentioned as virtual, but I do not believe he's not in. So we'll move to our unfavorable testimony, Mr. Scott Silverman and Robin Mangione. Thank you very much. I appreciate that.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, members of the Judicial Proceedings Committee. I am Scott Silverman, an attorney representing community associations for over 30 years. The Legislative Action Committee of the Community Associations Institute, on whose behalf I am appearing and testifying, oppose the adoption of the current bill, SB 787, even with the amendments that were spoken to during the favorable testimony for a variety of reasons. And they either do not go far enough, the provisions, or they go too far with regard to diluting the existing mandate. There is currently pending a much more comprehensive bill, which is House Bill 292, Senate Bill 63, which is being championed by Delegate Holmes, which will offer a much more comprehensive approach to fixing the issues that have been encountered with 107, which was the bill passed several years ago. Despite the testimony that was offered, this bill actually does exclude associations of under 4 stories or less than 4 units. It does limit the content of a reserve study to those items only costing more than $10,000. It does expand, if you read the text of the bill as written, does expand the category of professionals that can complete a reserve study to include electricians, plumbers, or home improvement licensees. They are not limited to simply providing cost estimates. That is not the text of the actual bill. And more importantly, it does not amend the Maryland HOA Act at all. It only addresses the Condominium Act and the Cooperative Act.
Thank you very much.
And the extension from 3 years to 10 years is simply too far.
Thank you very much.
Therefore, we urge an
I'm going to
unfavorable.
thank you very much.
Sorry.
All right.
Chair Smith, Vice Chair Waldstreicher, members of the committee, again, I'm Robin Manoogian with Community Associations Institute, Marilyn Lack. We also oppose the bill. The things that we're trying to do with Delegate Holmes, I think we can all acknowledge that he is trying to consolidate any number of the reserve study bills that we have, where the bill that took effect in 2023 may have been aggressive and a knee-jerk reaction to the tragedy in Surfside. We don't see the benefit of stretching this thing out for 10 years. The problem with that is there's no checks and balances. There's no way of assuring that associations are actually putting away the money. And the problem is today's boards are under the gun with reserving money to begin with. They get a lot of pressure from their owners to not put away money, to raise fees. And so extending this out 10 years, what you're going to end up with is people who actually move out of the association, then move into the association and are somehow hammered with a special assessment. Very critical. An owner's HO6, that condominium unit owner's policy, will not fund a special assessment. So we want to work with the JPR and Delegate Holmes to look at collating some of these ideas, but we believe that the ideas that are in this bill would not work, and we're asking for your unfavorable report.
All right, seeing no questions from the panel, I believe this ends the hearing for Senate Bill 787. Next, we will have Senator Charles, 682. For 989, what's your preference? 989. All right.
All right. Good afternoon, Mr. Chair, Vice Chair, and honorable members of the Judicial Proceedings Committee. For the record, I am Senator Nick Charles, testifying in support of Senate Bill 989, which is an real property unauthorized occupant, sheriff's property registry and removal. What this bill is designed to do is to protect property owners and renters by proactively preventing illegal occupancy and fraud. We have a big problem here in Maryland, and I'm sure you have seen the increase in ideas and solutions to combat it. This pervasive issue is squatting. Senate Bill 989 allows local sheriffs to establish a registry where property owners can list their properties. This registry would create a rebuttable presumption or a legal assumption that anyone on the property without the owner's permission can be safely removed without needing to go through a lengthy court process. This tool acts as a digital and physical no trespassing sign for the inside of a home, giving both owners and renters a straightforward way to protect themselves before problems arise. This bill is an important step towards addressing an emerging issue. While many bills focus on speeding up the recovery of a property, Senate Bill 989 tackles the problem before it escalates by preventing illegal occupancy in the first place. It's not about creating new crimes or additional barriers, but instead providing a proactive solution that helps both homeowners and renters avoid becoming victims of fraud. As we know, some people living in homes without authorization are victims of fraud themselves. These individuals may have been deceived by someone falsely representing themselves as the property owner or an authorized agent. With Senate Bill 989, renters will have the opportunity to verify ahead of time that the property they are renting is legitimate. helping to avoid these fraudulent situations. Senate Bill 989 does not require any jurisdiction to implement this registry, but we believe this tool can be beneficial, especially in areas like Baltimore City where local sheriffs have expressed interest in using it and are here to testify in favor of the bill. This option will be paid for through a fee-for-service structure like other services provided by the sheriff. While the bill does not set forth a specific fee, conversations with sheriffs have suggested around $100 could be a reasonable amount. While I acknowledge that there may be concerns about moving away from the court involvement, Senate Bill 989 is not intended to replace judicial process, but to offer an additional tool to help prevent illegal occupancy before it becomes a courtroom issue. Nothing that happens in court can prevent fraud or unauthorized occupancy before it happens. This registry offers a way to address this problem without increasing strain on our courts. There have been letters of opposition for this bill that believes that this bill will remove existing tenant protections. However, if you look at the bill on page 3, lines 9 through 11, it specifically states, the owner of a residential property enrolled in a registry or the owner's authorized agent may request the immediate removal by the sheriff of any individual occupying a dwelling on the property without authorization if the unauthorized occupant is not a current or former tenant of the dwelling under a lease agreement authorized by the registered owner. I want to make sure that that is very clear, that we are not putting people in a position who are current tenants in a position where they can be removed. This is about actual squatters who have never been in the house under any legal context. So this is to ensure that this process is used appropriately and fairly. And because of all of this, I urge for a favorable report on Senate Bill 989 to help property owners and renters protect themselves from fraud and illegal occupancy. This bill provides an innovative, practical solution that addresses a growing concern in all of our communities. I'd like to thank you all, and today I know there are quite a few and unfavorable testifiers here. We have a few favorable with amendments, and then I know for a favorable we have Baltimore City Sheriff's Office, Nicholas Blendy.
All right. Are there any questions for the sponsor? Seeing none. Oh, Senator Waldstreicher.
Thank you, Mr. Chair. And I know Senator Watson has a similar bill related to this issue. I just wanted to say thank you. I don't know if this is the solution or Senator Watson or some third solution. But just to put on the record, I know someone this happened to. In Prince George's County, he deployed overseas. There was a month gap between when he deployed and when the tenant to whom he rented was going to take possession of the home that he was renting out. In that month, a squatter took possession of the house, and the squatter believed, because of a scam, believed that he had a legitimate lease to the house. And so you've got someone fighting for our country overseas, trying to get out a squatter who actually wasn't the scammer. And it is Kafkaesque. Like, if you are the property owner, trying to get someone out of your home who doesn't belong there and who has no legitimate lease, and with police saying, hey, this is a landlord-tenant dispute, you got to take this to court, and then trying to navigate that from when you're not local to the area, to the home that you own. It's just, I know this is an isn't it so question, but it's hard to express how dispiriting that is for the person who owns the property, who simply just wants their home back for themselves. Isn't that so?
Isn't that so, Mr. Vice Chair? I couldn't agree any much more. it's a unfortunate issue on both sides. But for the person, you know, a lot of small landlords, or even if this is your personal house, can you imagine? A lot of us are gone from from our homes and stay out here in Annapolis, and you go back to your house, and somebody's literally in your house, and you have to go through the courts to get them out. You know, that is, you know, extremely egregious. And we need to have some level of provisions in place that protect not only the homeowner, but the person who may necessarily been a victim of fraud themselves. And so I believe that this touches on a lot of ways that we can protect both parties at the same time, because I know that becomes an issue. But we need to make sure that we protect the homeowner who is also trying to get back in their house, because in that process, they become homeless themselves if you can't get back into your own house.
Senator West.
Thank you, Mr. Chair. I'm having a hard time, and it may be just because I'm not familiar with this bill, figuring out what it does. So right now, the owner of a home has an official registration called a deed, which is recorded in the land records. So this bill seems to require the person to file a second registration for fee with the sheriff, saying what would a filing with the sheriff do to supplement the information already provided in the deed in order to establish that the homeowner owns the home?
So one of the unfortunate parts about squatting is one or two things. Sometimes people make fraudulent leases.
Right.
And they present this fraudulent lease. So no matter if your name is on the deed or not, if a fraudulent lease is provided to a sheriff, that sheriff is now stuck in a position where they say, this is now a landlord-tenant issue. And so no matter that your name is on the deed to the house, if this is somebody's in your house, they provide this information to say it's an actual lease. There's no true way to get them out unless you go through the court process.
But how does, if you already have a deed on file in the land records, how does filing an additional piece of paper called a registration form with the sheriff improve your status as the owner of the property? That's what I can't figure out. We already have a deed that establishes you own the property. Why should you have to file a separate piece of paper with the sheriff in order to establish that you own the property?
So what this will actually do is put it in perspective for the landlord, the owner of the property, and the landlord themselves, and then the actual the tenant. They'll be able to check into a system to say that this is an actual facility that's for rent, and it's actually tracked through by the sheriff's office. So when an issue does come about where somebody is illegally taking possession of somebody else's property, the sheriff can then have a system where they can go to and immediately get somebody out of that particular house. So this will just make things a lot simpler, simplify the process, and make it easier for both sides to realize. But right now, because we have nothing in place, there's nowhere to go for a renter. There's nowhere to go for a landlord. So this creates that box for everybody to be safe on both sides, to know that this is an actual place for rent.
And then the other question I have is about the posting. It's a little like a no trespassing sign, but you have to post a sign on your property that says, what does it say? I'm the owner of the property and nobody else has a right to be on this property. It's similar to no trespassing. But wouldn't it be logical that if somebody really was squatting, that they would take the sign down?
Yeah,
and discard it? So what good would a posting of a sign do?
You know, having signs is like you said, it can be pulled down, right? And somebody can snatch something down and get rid of it. But we're trying to come up with some logical ways to address this issue. And no way is the perfect way right now. We have multiple bills that have come before us. whether it's Republicans or whether it's Democrats. We all have this issue impacting us. So it's something that this is just something that we put in to allow for this to be addressed right now. If you think that it's unnecessary because that can be pulled down, somebody can pull this sign and discard it, you know, I'm willing to have conversations of how we can make it stronger. But we have to do something this year. We have multiple bills dealing with squatting.
No question. I really appreciate the fact that you introduced the bill. It seems to me we should, as a committee, sit down, take all the bills that we've gotten dealing with this and come up with a solution that makes sense. Because, as Senator Waldstreicher said, it's just unacceptable for someone who owns a home to be shut out of that person's home by someone who does not have legal title to the home and may be holding a lease, but a lease that was executed by someone with no authority to execute the lease.
Right.
And I feel sympathetic to the person who was defrauded, but I feel far more sympathetic to the owner whose house is being occupied with someone with no right to be there. Thanks.
You finally got a question on one of my bills.
Seeing no other questions, because of the way folk have signed up, I would like to call Nicholas Lindy. Is it? All right, who's signed up favorably? After you provide your testimony, then we'll bring up Krista McGee and Lisa May, who have both signed up favorable with amendments.
Thank you, Senator. Thank you, Senator Sidnor, Mr. Chair, Mr. Vice Chair, members of the Judicial Proceedings Committee. For the record, Nicholas Blendy, Assistant Sheriff for Baltimore City, and we are the people who affect the evictions and deal with landlord-tenant issues. And so, if you ask me the questions again, I'd be happy to answer them. But I only got 2 minutes, so I just want to get through a couple things first, Senator West. So, first of all, I do want to step back. I think the bill sponsor nailed it, that this is an attempt to be proactive, and we think of it as like consumer protection. Because in the broad universe of landlord-tenant disputes, you really have three actions. You have failure to pay rent, and there's a legitimate landlord-tenant relationship. Tenant holding over, which is there's some sort of relationship, but it's not necessarily failure to pay, but there is a lawful right for the person in the property to have possession. And then wrongful detainer, which is the action that there is no right to possess the property, which includes this squatting as a subcategory. And I want to make clear that right now, if no bill's passed, even if you're the victim of a fraud scheme and you were defrauded and you ended up signing a lease that was dummied up by somebody who had no right as a senator, we are still putting you out, even if you're the victim of a fraud. You go to the court, you get a wrongful detainer action, and then you file for the writ of possession or warrant of restitution, and we serve that and we evict you. Why we're interested in being proactive is wrongful detainer actions have about 4 times more contact with people on premises. So you're 4 times more likely to interact than just a failure to pay. Failure to pay, people tend to either pay or work themselves out or aren't there when you do it. So we have a vested interest in this. And I want to say this, I've written testimony, and I won't belabor it, but we are attempting to be proactive, right? And so with this registry, and I'll answer that question if you ask it, the idea is we would be a public notice campaign and a branding campaign and a registry that can be checked because we don't want these people to end up in this situation. So for the foregoing reasons, we're happy to work with anyone on any amendments, and we ask for a favorable report. Happy to answer any questions.
Senator West.
Mr. Blendy, good to see you again.
Thank you, Senator.
It's been a couple of years. So my thought of how the problem I think with having the sheriff make these decisions is that the sheriff is not a judge. And it's hard to imagine how you would appeal from a decision of a sheriff. In the courts, there are recognized methods of appealing. My thought, in terms of how we solve the problem, is I know there are provisions of law which require the circuit courts to act promptly. A couple of years ago, somebody filed their candidacy to run against me, and I knew they weren't living in my district, and I went to the law, and I found, much to my surprise, that the law provides that if there's a challenge made to someone's right to run, the court must attend to it and resolve the issue within 1 week after the case is filed. So it would be possible for us to pass a bill which would require the circuit courts to deal with these issues quickly and not in a prolonged fashion the way frequently is the case. what would you think of that as an alternative to having the sheriff deal with this?
Yeah, 100%, Senator. Thanks for the question. Agree with you on the structure, and we would be open to that, as I think was the bill sponsor noted. There are, I think, several different ideas for how to resolve that, and that is a very logical one. And if I may just sort of explain, I think the logic from the conversations that happened on a registry is what squatting is fundamentally, it is a burglary. It's a burglary of possession of, so it's already a crime. Now, we are represented by assistant attorneys general who are more able than me as members of the bar, and they have advised us, you know, even if you have facts on the ground that you're encountering, probably let the civil process work out for liability reasons. Because if you put somebody out erroneously because you thought that they were trespassing, and it turns out that they were, then you could be party to a libel. There's a whole Todman case that I know the advocates are very concerned, and they're right to be concerned about that case because the facts there were terrible, and that happened in Baltimore City. So what we thought here was if we could create a proactive registry where by paying a fee for service, a property owner could get that presumption that the property is not eligible for rent and not eligible to be leased. And this is protecting primarily the universe of constituents like Vice Chair Waldstreicher talked about who are abroad, or someone who's preparing a property for sale and they have it staged and then somebody comes and cuts the lockbox out and breaks in and squats, right? So how can we do something to prevent the process from taking unduly long? And if the answer is the court and the legislature are able to compel the process to happen rapidly enough, then I would agree that this bill is unnecessary if that's a way to do it. This is just one of the many ideas that was modeled off of as we had this, we noticed the uptick of wrongful detainers happening in Baltimore City. We talked to the landlord community. We talk regularly to the tenant advocates. And I will say that every concern that they raise is legitimate, and we are open, like I said, to work through any of it. We regularly, for example, to your point, since you know how landlord-tenant actions work, if we have uncertainty as we're serving a warrant or the eviction, we will then pause. If the facts on the ground don't match what's on the paper, we'll go back to court that afternoon. This could even be amended in such a way to make it the sheriff becomes an agent, and then the agent, we refer it when we see the facts on the ground. But fundamentally, what I fear if no action is taken, I feel some sheriff, probably not the Baltimore City Sheriff, almost certainly not the Baltimore City Sheriff, will charge somebody with a 4th-degree burglary or whatever the degree it is. And now you're piling a criminal charge on top of somebody that is the victim of a fraud scheme. So we're welcome to answer questions, welcome to be a partner in solving it. And if you solve it that way, Senator, that's the way to go to the General Assembly. We will follow that as we do the law now.
Yeah, thanks so much for your answers.
Additional questions for Mr. Blendy? All right, excellent, thank you. All right, so it's Krista McGee here and then Lisa May.
Thank you, Mr. Chair. Mr. Vice Chair, Krista McGee is across the hall. You'll just have to settle for me today. Lisa May with Maryland Realtors, here favorable with amendments. Before I start, Senator Charles actually helped with the squatting situation that one of the officers of our organization was experiencing. So we thank him for that and thank him for bringing this bill. As was mentioned, this is not going to address every instance of squatting, but as an organization, we're supporting any and all proposals that improve the unlawful detainer process that is currently not working for property owners who have had their properties confiscated from them illegally. We do have suggestions in our written testimony on possible amendments. The first, Senator West already flagged what happened if that notice is taken down. Related to that, some of our members had some concerns that posting a notice is almost like a giant red flag saying, hey, this property is vacant, and it may perversely encourage someone to break into the property and occupy it illegally. Next, we also want some clarification on whether this registry would stay with the property or the property owner. If this is being used during a home sale, that is a very sort of delicate time when property is transferred from one owner to the next and is a prime opportunity for squatters to take advantage of that vacancy and that transition. So that is something that we would like to look at with this bill. As was mentioned, you all have very difficult decisions ahead of you. This is a very complex issue, but we're very encouraged that you are willing to have those conversations and willing to help these property owners who have been victimized by squatting. So with that, I'll ask for your favorable report. Thank you.
Excellent. Seeing no questions, thank you very much. All right, so that'll conclude the testimony for the proponents of the bill. We'll now move on to the opposition panel, and we'll hear Sharon Jackson as Mr. Hill here. Kira Wellborn, Catherine Davis, and that's it. Excellent.
Good afternoon again, Mr. Chair, members of the committee. Again, my name is Matt Hill, Public Justice Center, which is a part of Renters United Maryland, which strongly opposes this bill. I have great respect for the sponsor and understand the intent, but unfortunately the bill suffers from the same fundamental flaw that the other bills before this committee have suffered from, which is to take the court out of the court process around wrongful detainer. It appoints the sheriff as the judge, jury, and executioner in a number of eviction cases. You're going to hear, I think, more about the fact that this is unconstitutional from other folks who are going to testify. But we've been up here before. We've talked about multiple scenarios in which this goes wrong. Some are the victims of fraudulent scams. Others are predatory property owners and landlords who will take advantage of this situation, put their property on the list in order to then evict a troublesome tenant. There are domestic disputes to which this would apply too, and could also be a source of some really terrible situations. Florida is one of a handful of states that's passed a law like this, and linked on the first page of my testimony is an article about exactly how this goes wrong. So it's the Pensacola renters who were evicted. The gentleman who claimed to be the owner, was not the owner, went to the sheriff, swore out an affidavit. Everything was false in the affidavit. And then the sheriff evicted these poor renters with no due process, and the landlord proceeded to then sell all their belongings, including their wedding ring. It's absurd and it's unjust, and Maryland should not follow Florida down this path. I just want to point out that this idea of the registry of vacant properties is going to provide effective notice to renters is just simply not grounded in logic or reality. No one is going to say, hey, I'm desperate for affordable housing. Let me go to the local sheriff's website and look through the registry of available or not available units. It just simply won't happen. And so it's not going to provide effective notice. It's not a balanced approach. We're happy to work on amendments, but we do favor court process. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. For the record, I am Kira Wellborn, an Assistant Attorney General with the Consumer Protection Division of the Office of the Attorney General. The Consumer Protection Act mandates that the division take strong protective and preventative steps to investigate unlawful consumer practices, to assist the public in obtaining relief from those practices, and to prevent those practices from occurring in Maryland. As such, the division mediates and investigates complaints from Maryland consumers regarding unfair, abusive, and deceptive trade practices, and seeks to remediate violations of the Act through enforcement actions. It is in this role I am here today in opposition to Senate Bill 989. Contrary to testimony you heard earlier, Senate Bill 989 is not a consumer protection bill. Indeed, Senate Bill 989 seeks to address squatting by enacting extrajudicial ejectment process that could promote unfair, abusive, and deceptive trade practices. First, although the bill attempts to address unauthorized occupants, the bill could ensnarl lawful occupants and force them from their home with little notice and no opportunity to challenge the removal before being ousted. The risk of improper ejectment is increased because the bill does not require the sheriff to evaluate as to whether the home is unlawfully occupied, as would occur through a judicial eviction proceeding. As you've heard from my colleague Matt Hill, this exact scenario has played out in Florida, where renters were forced from their home by the sheriff after a bad faith request. Additionally, the voluntary registry created under Senate Bill 989 would not prevent the abusive, unfair, and deceptive trade practices that concern the division. First, to be added to the registry, the property does not need to be vacant. As a result, bad faith owners could weaponize the extrajudicial proceedings to remove lawful occupants. Second, the registry may not be publicly available, thus withholding material information from potential victims of scammers. And finally, I think the registry could be misleading. It's unclear whether a renter would be seeking information about whether the property is actually available to rent. For these reasons, the division recommends an unfavorable report.
Good afternoon, Chair, members of the committee. My name is Catherine Davis. I'm the director of the PBRC's Courtroom Advocacy Project. We represent tenants in eviction-related litigation. Last year, we represented over 300 tenants and talked to over 1,000 on our hotline. And we're opposed to Senate Bill 989, mainly due to the unintended consequences that you've already heard about that will happen when you take the judicial process out, take the judicial oversight out of the eviction process. We have so many clients who come to us with wrongful detainer actions who are actually legitimate tenants. In my written testimony, I've described potential unintended consequences, especially on low-income tenants. You also have detailed testimony from one of our clients, Mr. Raghugar, who is a rightful tenant who would be living in his car right now if this law had been in effect when his landlord decided that he no longer wanted to rent to him. So I urge you to consider that testimony. And you've heard a lot already about how this bill will result in unconstitutional evictions. I'd like to focus on the fact that what this bill does is it really conflates the relative importance of financial and economic right to property with the human right to a home. We recognize the importance of allowing people to protect their financial assets. That's why we have trespass laws and the wrongful detainer statute, to allow homeowners to remove unwanted people from their property. However, constitutional law dictates that when we consider laws and government actions, we have to weigh the relative importance of the rights at risk. We must measure the risk of temporary loss of an asset against the permanent loss of a home. By definition, none of the properties that could be protected under Senate Bill 989 are being used by the owners as a current home. However, the very real clients that we represent who are at risk of being evicted without any judicial oversight are, by definition, using their property as a home. I urge you to carefully consider what you're doing with this bill and others like it, and to issue an unfavorable report on 989. Thank you.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Leslie Dickinson, attorney with Disability Rights Maryland and a resident of Carroll County. I'll just add that the burden of this bill is completely on the tenant occupant of this housing and somewhat on the sheriff's department. There's no onus whatsoever on the affiant. And there's also no requirement in this bill, in fact, that Senator West mentioned. The owner would have a deed. There's no requirement that the alleged owner produce a deed, that they show from land records, that they show that there's no litigation, because that's another requirement, that there's no litigation between the occupant and the alleged owner. There's basically, the onus is all on the sheriff's department if they're going to actually follow the requirements of this bill. They're the ones that have to collect all of the documents and information to ensure that the affiant is actually telling the truth. So that's just kind of mind-boggling why they don't have to provide the information themselves. There's also, as Matt Hill mentioned, the potential domestic violence. I mean, there's language in the bill that says, that it's not a family member, it's not this, not that. But again, there's no requirement that this person, other than that they're swearing an affidavit, that there's not a domestic violence protection order and that there's not some other litigation. So for all of the aforementioned, well, I would just add also that, as Senator West also mentioned, there's no appeal, there's no oversight for the occupant. They would have to bring an affirmative lawsuit against, this person if the affiant is lying and they don't get any emotional distress or statutory damage. So, thank you. I urge an unfavorable report on this bill. Thank you.
All right, we have a couple questions for this panel. We'll start off with Senator Charles.
Thank you, Mr. Chair. I'm a little concerned, and I just kind of want to walk through some scenarios that, personal to you all, if you'll indulge me for a sec. So I want to figure out if it's safe to say that if a robbery suspect or a trespasser comes into any one of your homes, is it safe to say that if either one of those particular lawbreakers has a fake lease on them, when they come into, when you come back home and see them in your house, you're gone to go grocery shopping, come back home and somebody's in your house and they have this fake lease, it seems as if they will have more protections, even though they're breaking the law, they're in there as a robbery suspect or they're trespassing, they'll have more protections. We'll have to go through the court just to get them out the house because they have the fake lease. It almost incentivizes criminals to walk around with fake leases if they're breaking into people's houses, and it'll give them more protections because you'll have to wait for a court a couple of weeks or 2 weeks or 3 weeks before you can get in front of a judge. Is it safe to say that that is something that could possibly happen if somebody breaks into your house and they just keep a lease on them? It gives them protections?
Well, I'll let Matt. I think that's a great question for the police representative who was just here, because that would clearly be a crime. But I will just point out that under this legislation, it wouldn't matter because my home that I'm living in could never be on this registry, right? So that could be a valid question for a different piece of legislation, but it doesn't really impact this piece of legislation. I don't know, Matt, if you have anything to add to that.
I mean, I completely agree, and I think that if that happened in my house, I would call the police, and the police would come, and it would be a robbery, it would be a break-in in progress, and they would remove the person from my home, I would assume. And I also just, if I could, real quick, I'd add that, you know, I appreciate the hypothetical, but I'm reminded when I'm testifying here that this committee works a lot on data. And so, you know, these are not, we haven't heard a lot of testimony about people going out to the grocery and coming back and finding somebody in their home, and that's what this committee is trying to address. So there's no data to support the need for this legislation, frankly. I mean, we haven't heard any. And so I feel like if we're going to make this major change in the law, it needs to be supported by data.
I beg to differ. I think if you do the quick YouTube lookup or a quick Google search on squatting, you'll see just enough data to see that it's a national issue, and it's happening in a lot of communities. And the fact that the bills are being brought forth by bipartisan across the board, across the state in different types of jurisdictions, it's obviously an issue. So I think it's safe to say that there's enough data out there that shows that there is a problem that exists.
I mean, I will say that this is this isn't, but there are bills before the committee that are model legislation from the American Legislative Exchange Council, which is an institute, a think tank that is promoting this bill throughout the country. So it's not surprising to me that we're seeing a lot of these kinds of bills, for sure.
Okay. Thank you. No, that was it. No.
Thank you very much. I don't think I see Ms. Strawn here, but I was looking at testimony in opposition from the Attorney General's Consumer Protection Division and wanted to get your take from looking at the testimony. She writes, the extrajudicial eviction created by the bill does not provide meaningful notice or an opportunity to be heard. I read that as there's no due process as a part of the process. So then the question that I have is, does someone who is in unlawful possession of a property, do they get to have due process?
Thank you for your question. So Kira Wilpon-Wellborn, Assistant Attorney General with the Consumer Protection Division. Again, the division has serious concerns about the notice and opportunity to be heard that is provided for within the bill. Counsel to the General Assembly for a similar bill, Senate Bill 556, provided a lengthy analysis about the constitutionality of that bill, including the concerns that the bill didn't provide notice and opportunity to be heard. I think those similar concerns overlay to this bill as well, and would recommend the committee seek counsel to the General Assembly's advice for a full analysis.
Thank you very much.
Thank you, Mr. Chair. Ms. Wellborn, as long as you're up there, or maybe Mr. Hill, one or the other, I've read the letter that was issued by the Attorney General 2 weeks ago to Senator Love, indicating that there are constitutional issues, significant constitutional issues with bills of this type. Let me call your attention back to the solution I suggested earlier, which is that instead of going to the sheriff, you'd go to the court, the circuit court, but that we would pass legislation requiring the circuit court to address this issue and resolve it really expeditiously. Now, I mentioned a week, maybe we'd want to say 2 weeks. Do you think you'd have the same constitutional issues if the circuit court were to take up these issues and in a very abbreviated fashion, we're able to hold an evidentiary hearing, hear from the witnesses on both sides, and then come to a determination of who should possess the property in question?
I think that is an excellent question for the Counsel for the General Assembly, not to try to evade the constitutionality question, but because there are so many factors to consider when evaluating notice and opportunity to be heard, including whether that notice is expedited or the hearing is expedited, and what the potential deprivation of property rights are at the end of that hearing. It's an analysis that the Counsel to the General Assembly should really be a part of.
Okay, well, I guess it's always possible to imagine hearings in which due process is denied because things are so quick that you can't get witnesses together.
Exactly.
But I would assume that if I owned a piece of property and there was a deed in the land records and it had my signature on it and I could provide an exemplar and maybe bring an expert on handwriting to establish that that's me, and there's no such signature on the deed because I never signed, on the lease, because I never signed the lease, it would be not too complicated for a court in a brief period of time to evaluate the issues and come to a resolution, a fair resolution, which could always be appealed by the losing party.
Correct, Senator, but it's also the opportunity for the opposing party to be able to know of the hearing and to be able to present a defense.
No question. You'd have to give them the service, but the service would include a notice that the hearing would be held 10 days in the future, which would give them an opportunity to hire counsel, sit down and explain the case, get any witness, subpoena witnesses if needed, and get them into the courtroom. What I think everybody is grasping for here is a way to get these issues, these squatting issues, resolved quickly. And I agree with Senator Charles. This is not an isolated case. These things happen with some frequency. And it's our job as legislators to figure out how we're going to handle these things and provide justice as quickly as possible to people who have been treated unjustly.
Understood.
Thank you.
I guess that just a general question without the specifics, because we're still going to work out the details this week, but just for the wrongful detainer statute as it exists right now, the thought is just about expediting that process and providing for. First of all, what do you generally think about that? I'm just looking at the statute now, and there's an idea kicking around just to expedite that process. And then I want to have one follow-up question.
Yes, Mr. Chair, Matt Hill, Public Justice. Yes, we're much more open to that conversation. Court still involved, exactly. Our concern in that situation is just to what Senator West was pointing out, is that, you know, these are not served by personal service, right? There's no one actually making contact with the defendant in the vast majority of cases. It's just nail and mail service from the sheriff. And so we want to make sure that folks are served in a way that provides them enough time to be able to take off work, to arrange for childcare, to reach out for counsel if that's what they want to do, so that they have that time from service to trial to be able to mount a defense if they have one.
Got it. Okay. So not so short of a window in which it would pose logistical complications, but at least there's, I mean, they've worked out the service process in this statute. I think that's pretty well thought out. But truncating the timeline is not super offensive to you. I mean, I know there's going to be some pain, but I just that's less of a painful avenue for you all.
Much less painful.
Okay, got it. I mean, that way you kind of balance it out. You get the court involved, but you also expedite the process, get these things resolved quickly, because this is a problem. Okay, excellent. Just Any other further questions? Awesome. Thank you very much. Thank you. All right, so I see John Kern is not here and Nikika Namdi is not here. Is Leslie, oh, Leslie Dickinson just testified. There you go. Have I missed anyone who signed up to testify in opposition for 989? Okay, with that, that will conclude the hearing for Senate Bill 989. We'll now move on to Senator Charles with Senate Bill 682.
I'm going to call up my sponsor panel, Kathleen Highland, the Deputy Commissioner, the Office of Financial Regulation, Meredith Merchant, Assistant Commissioner for OFR, and Claudia Wilson Randall, Executive Director for the Community Development Network of Maryland. All right. Good afternoon, Chair Smith, Vice Chair Wallstreicher, and honorable members of the Judicial Proceedings Committee. For the record, I am Senator Nick Charles, here today to introduce Senate Bill 682. First and foremost, I want to thank the cross-file of the bill, Delegate Dana Jones, for alerting me to this incredibly pressing topic. This practice is predatory, it's unfair, and it's more than disheartening to know it's happening. As soon as I gained knowledge on what happened, I knew we needed to enact change to protect Marylanders. Senate Bill 682 is a crucial bill. It seeks to establish much-needed protections against sudden foreclosure proceedings that disproportionately impact Maryland's most vulnerable communities. Materially delinquent mortgages, commonly referred to as zombie mortgages, are very old mortgages that have typically been written off or charged off by the original lender and then sold, often multiple times to the debt collectors. Many of these debts originated before the 2008 mortgage crisis, before Dodd-Frank and the Consumer Financial Protection Bureau, when it was common for the lenders to qualify homeowners for an 80-20 mortgage. These loans were structured with an 80% first mortgage and a second mortgage to cover the 20% down payment. I actually engaged in this loan style when I purchased my home, and I know many in this room may be familiar with this process. If you don't know, a lien in the second position can only collect proceeds from foreclosures after the first lien is fully paid. After the financial crisis and a significant drop in home values, many of these second liens were discharged, modified, written off, or charged off by the original lenders or servicers, especially after being bailed out by the federal government. This bad debt was then sold to debt collectors for pennies on the dollar. With the understanding that the debts could become valuable once home values recovered. From the consumer's perspective, understanding what happened to the loan once they were told it was charged off was often difficult. But what mattered most was that they assumed they no longer had to make payments on the debt. Fast forward a decade or more, and home values have recovered significantly. As a result, second liens that once had no value in foreclosure proceedings now do. In recent years, private equity firms, debt collectors, and other parties have begun foreclosure proceedings against homeowners who were unaware that these debts still existed, let alone that they were still receiving monthly statements. Let me repeat, they were unaware that these debts still existed. This afternoon, my staff emailed each one of you about 1 o'clock, so if you go into your emails, they emailed you a link to 2 maps showing the spread and impact of zombie mortgages across the state. These mortgages have affected every corner of Maryland from Wacomico to Garrett County. The second graph in the email highlights how disproportionately these mortgages have impacted communities of color and our working families. Zip codes with the highest number of zombie notices of intent to foreclose, NOIs, are demographically predominantly Black and Hispanic. In Prince George's County, 4 zip codes with over 80% Black or African American populations are among the hardest hit. While zombie mortgages make up a very small percentage of all foreclosures, it is clear from the data that they are stripping wealth disproportionately from low to moderate income communities and communities of color. I invite you to look at the data and see which of your constituents are impacted by this practice. This legislation does not propose to eliminate the debt or to stop foreclosures. It will require lien holders to fulfill their duty of providing monthly billing statements before initiating foreclosure proceedings. This 24-month period will give homeowners who may have been completely unaware of the debt and were not receiving statements ample time to make informed financial decisions for themselves and their families. This bill ensures transparency, giving homeowners clarity on their financial standing so they can make informed decisions before foreclosures actions are initiated. For creditors already providing monthly statements, this bill would not affect their ability to foreclose. Additionally, this legislation would allow homeowners to raise a laches statute of limitations defense in a foreclosure action for materially delinquent mortgage as defined by the bill. As the Office of Financial Regulation can further explain, since 2018, over 3,000 mortgages have received a notice of intent to foreclose for materially delinquent mortgage. While this represents less than 1% of all foreclosure proceedings, the impact on these homeowners is significant. Based on OFR's data, the average amount of homeowners in these cases will need to pay the mortgage holder in order to avoid foreclosures is over $193,000. These loans, along with the unfair practices associated with them, are predatory and pose a serious threat to housing and economic security for affected families. Over a dozen other states have passed legislation to regulate second mortgages. Last year, the Virginia legislature unanimously passed House Bill 184, which specifically addressed zombie mortgages with similar provisions. Additionally, current federal law is insufficient to protect mortgagees in these circumstances. The CFPB has had its doors locked under the current federal administration, and there is nobody currently enforcing protections on the books. Furthermore, those protections in the book do not cover the scope of protections in this bill. I also want to point out that there is a small technical amendment that simply corrects a small drafting error. Finally, I want to highlight that you will see favorable testimony in your floor system from the Consumer Protection Division of the Attorney General's Office, as well as many other organizations. Additionally, the favorable witness panel today includes OFR Community Development Network of Maryland, Maryland Legal Aid, Maryland Economic Action and Community Legal Services. This is a good bill and a bill that has a lot of support. The committee and the body have consistently worked to protect housing rights for Maryland's most vulnerable citizens, and I believe this bill is a crucial step in continuing that important work. With that, I respectfully request a favorable report for Senate Bill 682, which will help prevent consumers from facing surprise foreclosure notices when they have not even received a monthly statement, and will give them the opportunity and time to make informed decisions before the foreclosure process advances. Thank you.
Good afternoon, Chair Smith, Vice Chair, and members of the committee. For the record, my name is Kat Highland, and I'm the Deputy Commissioner of the Office of Financial Regulation, where I oversee licensing, mortgage supervision, and enforcement units. Thank you for the opportunity to testify in support of Senate Bill 682. Not sure there's much left to say because the senator did such a good job outlining our position, and I'm here to affirm a lot of what he has said. But to expand on a lot of the legal nuances, I want to highlight a couple of issues for you today. The first issue is that it really is a detriment to consumers that there is no statute of limitations on foreclosures. Maryland law has a long-standing sentiment and case history of stating that foreclosure is considered an equitable remedy, and so this in turn leaves homeowners vulnerable indefinitely to what we're calling zombie mortgages, the long dormant often second mortgages that resurface often after being sold to debt buyers who initiate foreclosure years or sometimes decades later. We're also seeing in OFR complaints a pattern of unfair surprise foreclosures. We see consumer complaints about these where borrowers are, in spite of what you might hear in opposition, are current on their first mortgages or have paid off a first mortgage entirely, yet debt buyers sue without proper notice to first lien holders. New unknown servicers appear with different names that aren't common to the industry and high amounts that cause borrowers to suspect fraud. They think the foreclosure is bogus and they might often get advice from their first loan holder not to answer, that this is some sort of scam. We also see the lack of laches protection being a significant detriment to homeowners. Maryland courts have not applied the laches protection to prevent foreclosure on these long dormant mortgages, despite homeowners relying on lenders' prolonged inaction when making their financial decisions. Now, to note, under the Federal Truth in Lending Act, lenders cannot charge interest without sending statements. This bill would correct all of these problems, and we urge a favorable report. Thank you.
Good afternoon, Chair, Vice Chair, and committee members. For the record, I am Meredith Merchant, Assistant Commissioner in the Office of Financial Regulation. I oversee the units that investigate consumer complaints, conduct outreach, and collect mortgage and foreclosure data. The Senator and Deputy Commissioner did a great job of talking about the data and defining some of the terms. I'm going to talk a little bit more about homeowner experience. So as you've heard, many of the zombie loans that we are now seeing are second mortgages that were originated years ago. Homeowners with these types of loans have often obtained a loan modification or filed bankruptcy to avoid foreclosure and believed that their second mortgage was included in that, especially if both the first and second mortgage was originated by the same lender. Homeowners don't understand that they still have that liability because they stopped receiving correspondence about the second mortgage loan after it was charged off. Homeowners receiving notices demanding immediate payment for these mortgages from a company that they don't recognize typically believe them to be scams or a mistake. I spoke to a frightened homeowner who called our office because she received a notice demanding payment of over $200,000. She didn't recognize the debt as her old charged off second mortgage because the original amount of that loan was $74,000. And she thought that that was included in her prior loan modification. She also didn't recognize the name of the company making the demand, and she assumed that it was a scam, and she did not engage. She didn't realize what was happening until after the foreclosure sale. This scenario is particularly prevalent in certain communities with predominantly minority populations, as you've heard, and as the data that our office provided reflects. Thank you.
Good afternoon, Claudia Wilson-Randall, Community Development Network of Maryland. And I want to speak strongly in favor of Senate Bill 682. And I think that the previous panelists have done an excellent job of outlining this problem in a macro manner. But I do want to also just, you have my written testimony, but I do just want to share a story because I think it's really illustrates this problem and how it plays out. So some of you may be familiar with Warren A. Brown, who's a popular defense attorney in Baltimore City. He experienced a zombie mortgage issue and was featured in a June 4th, 2023 Wall Street Journal article. So I'm just going to read a little bit of the article. Warren A. Brown was flummoxed when he got a notice last fall telling him that the Randallstown, Maryland home he lives in was subject to foreclosure. The reason, he learned, failure to make payments on a home equity line of credit taken out in 2006. Brown hadn't known the second loan existed. He said he moved into the house and started paying the primary mortgage in 2010. His brother, an architect who designed and owned the house, died in 2015, and the house is now owned by his estate. I had been paying a mortgage for 13 years, Brown said, so I didn't understand it at all. The owner of the second loan is First Key Master Funding, a collateral trust, according to an affidavit from a lawyer who filed foreclosure paperwork against the estate. The affidavit said the estate owned about $180,000, almost half was interest, the affidavit said, and charged at a rate of 6.25% for more than 14 years. So this plays out to African Americans who are not just at the lowest end of the income spectrum, but throughout others. So I just put that out there, and I also want to say that this is not legitimate debt. Debt collectors purchase this debt for pennies on the dollar. They're like lottery tickets on the ground, and then they go after them. And with that, thank you so much, and I look forward to your favorable report.
Excellent. Thank you. Questions from the committee? Senator James.
I am so unfamiliar with this, so I do have a couple of questions. I do understand, you have a primary mortgage because you bought your house, and then you would, once equity builds up, let's say, and you would get, a line of credit, they call it, or I think line of credit, or I guess others would call it a second mortgage. I'm not certain if they're identical, but it might be, right? Or it might be a little different. Okay, so the homeowner has bought the house, has a primary mortgage that they understand. Then that homeowner, or what you're saying is the homeowner then gets either like a line of credit based on the equity and or a second mortgage. That's my first question. Is that what's happening? Okay. Then I guess the homeowner becomes delinquent, not on the primary mortgage, but on the second mortgage and or line of credit. Okay, so is that what we're talking about?
Maybe both. It depends on the circumstance.
Pardon me?
Maybe both. It depends on their circumstance, but it could be one or it could be both.
Got it. Okay, so then on the second line of credit or second mortgage.
You can just call it second lien if you want. It's easier.
Second lien, okay. They become delinquent, and then the issue is, what? Is it, you're saying it is written off, which I didn't quite understand. I mean, I've heard that term, but I don't know what it means legally and if it has a legal definition, or what would be the legal way to describe that, and then I'll ask my next.
So charge-off is an accounting term which states that the debt is not active anymore for the lender's books, but it doesn't mean that it's uncollectible. So it's not supposed to affect the consumer's rights. It's just, this is charged off. And if you want to...
What's the legal implication of a lender charging off a second lien?
So it's a requirement with most any debt by the OCC, the federal OCC, that you keep your books this way and you charge off old accounts. And it's confusing for homeowners because they might think it's uncollectible, but if you want to keep collecting on mortgages for charged off, after they've been charged off, then under the Federal Truth in Lending Act, you have to send out monthly statements to the homeowner. You don't have to, but if you want the interest and you want to keep collecting on them to accrue.
So you can charge off, but that doesn't mean it's not collectible.
Right.
And to keep it collectible, you must.
And I'm sorry, I misspoke there. To keep the interest accruing and to charge more interest and fees, you have to send out monthly statements.
Okay,
you can
so
collect
you
the
could
principal
still have,
balance and where you were when you charged off.
So you could have a still collectible debt, but in order to get the accumulated interest and fees, you must then send a monthly notice.
Yes.
Okay. So you're not trying to stop the charge off with that we're not trying to collect the interest. This bill is narrowly tailored to the interest accruing because that violation of the monthly.
Right, that's not our intention, but they would have to send the notice requirements under the proposed legislation to keep it active.
So what we have here are companies, either the original lender and or subsequent purchasers for pennies on the dollars, not complying with a federal law that says if you want to collect interest, you've got to send these monthly notices.
And they don't have to comply if they just want to collect what the debt was when it was charged off. Yes, but otherwise, yes.
Okay, so why don't the borrowers put up the obvious defense? You didn't comply with the federal law, you didn't send the notices, so yeah, you can get the principal, sure, but you're not going to get, 20 years, 5 years, 13 years of interest because you didn't comply. I mean, to me, that's the defense. Right,
and they still have that defense in the status quo. You are correct on that. They can raise that. This gives them more time to deal with it before a foreclosure action is filed against them. And what we've seen before a foreclosure action is filed against them, we're requiring notice prior to the filing of a foreclosure in order to file a foreclosure. And that gives them an opportunity to reach out and say, hey, I don't recognize this debt. Can you do a verification under my rights under the Fair Debt Collection Practices Act and such, and can we get to the bottom of what this is?
So currently, what is the notice requirement or lack thereof for mortgage foreclosure?
There isn't one in this case for these old mortgages because what we have instead is a long tradition of case law which says, in most circumstances, we're trying to protect home ownership, and so mortgages aren't subject to a statute of limitations, and they don't accelerate prior to an overt act like a filing of a foreclosure, et cetera. So you don't have to send notices.
Well, I understand statute of limitations, but that's separate from notice. So I'm just trying to understand if in any other mortgage setting, and you want to start a foreclosure proceeding, you don't send notice of it, you do what?
You do send notice of material delinquency. I believe it's 36 days after the payment. And then Bill here from Legal Aid is.
Yeah, anybody that wants to answer, I just want to understand the process.
So basically, hi, my name's William Steinwhittle. I'm the Deputy Advocacy Director for Homeownership Preservation at the Maryland Legal Aid Bureau. I've been handling foreclosure defense for 10 and a half years, in bankruptcy and in state courts. So basically, in every foreclosure case, which is the current standard for all loans, including these zombie mortgage type loans. So you have to be in default at least 3 months before they can proceed with the foreclosure under FHA regulations, and that's also articulated in Maryland law as well. And then after that happens, they have to issue what's called a notice of intent to foreclose. So basically, that's the initial notice that is filed with the Office of Financial Regulation, registered with the Office of Financial Regulation, and then they can't do anything for 45 days. So the person has 45 days to cure whatever default is listed on that notice. And then once that 45 days passes, and no action has been taken, then the mortgagor can file what's called a order to docket, which is basically an order in circuit court permitting the person preventing the mortgage company from moving forward. So the notice of intent to foreclose has to be served by certified mail on the homeowner. The order to docket has to be served on certified mail to the homeowner and also has to be posted on the address of the property that is being foreclosed on. So that is the notice that they receive. It is an in rem action. Personal service is not required. And I apologize. I just didn't want to serve it.
No, it's very helpful. Yeah. So that's what would happen in a typical mortgage foreclosure, that process with that various notices. So where's the disconnect now with these, what kind of notice is not going, even in these, what you call zombie or second mortgage or second liens, this is still the notice you would get. Okay, all right, so that's the notice you would get, but this bill is saying there are circumstances where it's been so long, I guess, that the person is really taken aback. And so what we want to do is give them a little more time. Is that it?
A little more notice. Homeowners
Yeah, sorry. How much more time? How much more time is it?
Hi, Meredith Merchant again for the record. Yeah, homeowners in these circumstances really just need more notice, which gives them more time, because the current foreclosure timeline is not sufficient for them, right? So this bill doesn't like stop foreclosures or prohibit them from being, from the lien holder from being able to exercise their right. It just provides at-risk homeowners with time they need to confirm the debt's legitimacy, raise the...
Well, let me ask you this. What is the, in other words, if you have this situation and the notice has stopped going out, but it's only been less than a year, or very short time, I'm trying to figure out if there's a certain time duration between the notices stopping and a foreclosure proceeding happening on these second liens that you think triggers that they should get an additional, is it 2 years they get?
It doesn't elongate the existing foreclosure period.
Okay.
It's just that if you have one of these older than 5-year mortgages where nothing has happened for a while, you have to send out notices in advance of filing the foreclosure action. And then once you file it, the timeline is the same. And it's just because so much has happened in a consumer's life where they may have had a bankruptcy, they may have had a modification, and they often thought it was absorbed by, that the second lien was rolled into their underlying balance with all of the interest that's been accruing, or, and so on. So they've lost track of what was sometimes a $50,000 loan that comes back as a $200,000 foreclosure.
So the trigger is the 5 years, is that what you're saying? This bill protects people, and that's what I was trying to figure out. The duration that triggers it, that protection is 5 years of lack of notice.
Activity and payment.
And then once that's triggered, how much time does the homeowner and debtor, and you're not disputing they owe the money, but you're saying probably just the principal and interest up to the point that notice ceased, that would be what they would argue for. So how much more time does that homeowner get?
So it doesn't build in extra time for them.
I'm sorry,
It just says, I know it is confusing, I'm sorry. But in order to not make the law retroactive and to treat everyone fairly, it just depends on whether or not this was a prior to October 1st, 2027 mortgage. I mean, sorry, if you're bringing these actions, prior to October 1st, 2027 or after. And so what we're doing is creating notice requirements for the line in the sand being October 1st, 2027, after or before. And if you want to foreclose, you still can. You just have to send out 2 different types of notices. So if you are...
In addition to all the notices that were up here that we went over that are very standard.
Right, that's just when you start the foreclosure process. But say you own these accounts and you want to start foreclosing on them, then you just have to be aware that in Maryland, you have to send out a notice 24 months beforehand.
Oh, okay. 5 years passed. The debt. Good God, I'm so tired. The person that owns the debt, whoever that may be, has to, even if they buy it pennies on the dollar, have to sit on it for 2 years if it meets this 5-year lack of notice. They have to wait 2 years. Or they have to give 2 years, or they have to give notice and then wait 2 years?
No, they just have to have sent notice within the 2 years prior.
Right, so they have to sit on it for 2 years if they buy it.
So, well, sort of. They have to have sent notice within 2 years prior to the instituting of the foreclosure case.
Within, or they have to give up?
Within. They don't stretch it out by 2 years. They just, if they're going to file a foreclosure, they have to send a notice out within the 2 years beforehand.
Right, they really have to be forward, sort of strategically thinking that they want to do that. And what's the magic of 2 years? I can understand definitely adding time, I do, but 2 years, where does that come from?
So it's a construction of the legislation so as to enable companies that might own these mortgages now to still bring foreclosure actions instead of cutting them out of the process.
Oh, I see. You're doing it to deal with this before and after situation.
Because we didn't want to create a retroactive law.
I got you.
So instead it's, if you have one of these mortgages now, then you have to have sent a piece of correspondence a certain way within the past 2 years.
What happens
before filing foreclosure?
If you're trying to avoid this retroactive, but for those that are after, is October 1st, 2027? How does it work then?
So then, let me just check our bill here. On or after, a secured party may enforce the mortgage through a foreclosure or judicial sale only if the secured party has met the requirements of sending the notice for 2 years. So that's when that, and I'm sorry it's so wordy and tricky.
This is really
so
okay.
Yeah,
It's hard to follow.
after 2027, then you have to have sent it for 2 years before instituting foreclosure. So that if the bill passes this year, and you're responsible for knowing how to effectuate these foreclosure procedures, and our office will certainly send out an industry alert saying this is how it has to work with a list of sorts in it, then you're on notice from the change in the law and from us that you start sending out these monthly statements for 24 months. But before 2027, then you just have to have sent it during the period in the 2 years prior.
So you actually have to start sending out monthly notices for 2 years. Is that what you're saying? Is that what I just heard you say?
Once the bill is enacted, yeah. If you
notices to this debtor, that they owe this money for 2 years, you have to send those notices.
Yes, after 2027.
Why is that? Why is that going to? I mean, why that particular time period? I guess.
Because it wouldn't be possible for them to do it if we enacted it today.
No, I'm trying to
go
figure
back,
out going forward that not the old ones, but this is going to continue. We're not outlawing second mortgages, and all that stuff. And so I'm trying to figure out prospectively, we're going to protect homeowners with monthly notices for 2 years that concerning this, perhaps.
Because the whole problem in the status quo is awareness. I mean, again, a lot of these homeowners are current on their first, so they've been paying the bills that they understand they have to pay. And so when they're getting a new bill that looks bogus to them, they aren't paying it, but if they're getting a statement, they have an opportunity to contact whoever sent them the statement, who under the status quo now isn't sending them a statement.
Thank you. Here's my last question, because I thank you very much for letting me do this.
No, it's helpful for us too.
How does this bill stack up with you said 12 other states have laws regarding second mortgages? How does this bill, is this model legislation? Is this very, very similar to other states, or is it different? And if that's a long answer, you can follow up by just, telling me in writing.
I can't answer all the specifics. I'd be happy to follow up, but I know there's a lot of variety in state law because states like New York have a 6-year statute of limitations for accelerated mortgages, and we just have different ways of interpreting that law.
Yeah, I'm sure somebody is bringing this forward is very well versed in those 12 states. So if somebody can help us with a summary of it to cut down the time of reach, that'd be great.
And Maryland state statute of limitations are often different from the other states. So
thank you.
Thanks.
Thank you, Mr. Chair. I must admit I'd never heard of zombie mortgages before. So these are mortgages, second mortgages, not first mortgages, second mortgages, which the homeowner has taken out, which this homeowner at some previous time has taken, not a prior homeowner, but the current owner of the house has taken out and received money from a mortgage lender at some prior time, correct?
Yes, often second mortgages. We've only seen complaints, to my knowledge, of second mortgages.
Okay. So the homeowner took the loan out and received the money from the loan and signed documents creating a second mortgage on the homeowner's house. And the premise of this bill is that the homeowner forgot that the homeowner had taken out a second mortgage and gotten the money from the loan?
Yes and no. I'll agree with you. I will agree with you halfway on that. They might have forgotten, but it's also been the case that they had a bankruptcy or they had a loan modification with the first lien holder, or they had some other event where they changed the way they were paying the first mortgage. And so they believed—
The first mortgage.
Yeah, the first mortgage.
Not the zombie mortgage, the first
Right, exactly. And they believed that when they reset the clock after like 2008 and the crisis, and they reformed a lot under all of the different loss mitigation programs that were available, that this was taken care of in that bucket of what was changed. And if you look at a lot of what people agreed to pay, like the loan modifications that converted from temporary to permanent, there was a big bucket of money fees, interests at the end of that modification document that they agree they'll get to in the course of paying off their first mortgage. So a lot of them believe that it was all absorbed into that.
Well, no, wait a
then-
minute. If I take out, if my first mortgage is from First National Bank,
Yeah.
and my second mortgage is from Second National Bank, and then I somehow modify in some way my first mortgage with First National Bank, but I never signed any documents with Second National Bank, why should I be under any misapprehension that I still owe the money to Second National Bank?
Because you received a letter saying it was charged off.
What? Who sent me a letter saying my loan to
You're
Second
supposed to
National?
get a letter from the second mortgage company saying this is charged off.
Whoa, whoa. What?
Charged off, again, is an accounting term which says that the debt isn't alive on the creditor's books anymore.
So you're saying a Second National Bank sent me a letter saying my loan had been charged off?
That's what they're supposed to do under the existing federal law. Yes.
If it's been paid. But
No.
I think your argument here
No,
is
charged
it has,
off is when it's not paid.
What's that?
Charged off is when it's not paid. Satisfied is when it's paid. So
So
charged
the
off is
loan
an
hasn't
accounting
been
term.
paid, and the owner of the house has gotten a letter from the holder of the second mortgage that the second mortgage has been charged off?
Yes.
This happens?
Yes. And in 7 years, it will fall off their credit report, so it won't be on there anymore as debt that they owe because of the requirement that it ages off of the account.
Why would the holder of a second mortgage incorrectly send out a letter to the person who's supposed to make payments under the second mortgage?
No, it's
that
not
the second
incorrect.
mortgage has been charged off? Why would they do that?
It's not incorrect. It's an accounting requirement through the Office of the Comptroller of the Currency that when an account hasn't been paid for long enough, and this applies to credit cards, student loans, et cetera, if no payment has been made, they have to legally charge it off so it's not an active asset on their books.
Well, then the person who hasn't been making the payments, that's the person who owes the money.
Right.
Shouldn't that person know that that person has not made the payments that are required on the second mortgage?
Yes, and that's where I'm agreeing with you halfway, and we're not taking away the ability of that second lien holder to come and get that pot of charged off money. But if they didn't send out monthly statements showing an accrual of interest, then they can't collect anything beyond what that charge off value is.
And this is what, a federal law?
So yeah, the OCC accounting term is, and charge off is an industry standard. It's, yeah. But see, consumers often get that and they think charged off means I don't have to pay it, and oh, it's not on my credit report anymore. And in Maryland, we follow the legal standard of the least sophisticated consumer. So we kind of give them a little deference that maybe you don't know. But in spite of that, we're not taking away that second lien holder's right to foreclose. We're just saying if you want to collect more, you have to send out statements. If you want to collect this stuff before 2027, you have to send something within the prior 2 years. And then after 2027, you have to send something every month.
Okay, I've got to say, when I practiced law, I represented banks. And I have never heard of this. Does this happen frequently?
So we have data on 3,000 complaints.
In Maryland?
Yeah, or 3,000 mortgages in in Maryland, in our office.
Wow.
From the notices of intent to foreclose and files we've been able to glean. That's still only 1% of foreclosures in Maryland, so it's a small percentage.
Small percentage.
But it is a bucket, and because these cases are so strange and the homeowners are so blindsided, it prompted,
Who are the
forward
holders of these second mortgages that are sending out these letters
So that's-
incorrectly saying they've been charged off?
That's an important fact. So it's not incorrect that the charge-off letter was sent, but after charging off, a lot of the first lenders sell to debt buyers, and it's not recognizing these companies that come forward saying, you owe me the mortgage money, which maybe it was $50,000, now it's $200,000, that are causing homeowners and their first mortgage company to think this doesn't seem legitimate.
Explain this then. I'm sorry. This is so confusing. And
It is. It's bizarre.
bewildering. If I'm a second mortgage holder and I hold a second mortgage and I'm expecting to receive monthly payments on it, why would I not demand the monthly payments? And if the monthly payments aren't made, start a foreclosure proceeding. Why would I charge it off and sell it for pennies on the dollar to some other lender?
Because when a lot of this happened back in 2008, there was no equity in the home to collect. People were underwater. And so there wasn't any benefit to filing a foreclosure on the second. So that's why it made more money for the industry to sell the second as purchase debt, sell into the debt buying industry.
Okay, all right, now you're making some sense.
Thanks. There's so many components. I'm sorry. If we piece them together, it can.
It didn't compute until
Yeah.
now, but okay. So back during the Great Recession, homes went underwater, and the second mortgage holder knew if they filed a foreclosure proceeding, they would recover nothing.
Yes.
And therefore, they didn't file the foreclosure proceeding. Okay, thank you. That certainly helps to make it clearer to me what's going on.
And Senator West, if it's any consolation, I asked almost the same questions in both yours and Senator James's order when I first heard about this too. I was like, I don't understand what the heck is going on. How could you not know?
Okay. Now it begins to make some sense. Thank you very much.
Actually, those are all the questions, but the second then part is the matter of interest. Okay, so after you've gone through this process, there's a second mortgage. First, I was wondering how it has become zombie debt, so I get it. Now that makes sense. There's no interest, there's no equity to collect. Got it. It goes into a debt buying industry that sometimes gets sold once, twice, 3 times, 4 times, whatever. So what happens to the interest on that initial loan? And tell me, you said something about interest, and I didn't pick up on the thread. So what is it about the interest? How is that? Is that still able to be collected? Is that, what's the?
So my understanding, and someone else can correct me if I have this wrong because it's specific too, is that if you've sent a charge-off statement under the Truth in Lending Act, the federal law, if you want to keep collecting interest, then you have to send monthly statements saying this is how interest is being computed on your debt.
So then the debt buyer would have to initiate that, or would the?
All right, there's a correction on this part. And I'm going to take it because I want us to be right.
My name's Eric Warr. I'm attorney for Community Legal Services. I do foreclosure prevention, and I deal with clients directly. And so home equity lines of credit are not 100% covered by the regulations the same way that all normal mortgage are covered. So sometimes the requirement to send the statements is not actually covered under the regulation, and so they can just come and charge interest and demand the interest no matter what. So it really depends on the nature of how the home equity line of credit was written when it was initiated, whether it was open or closed-ended. So that's an entirely different thing because it all depended on how they were written when they were initiated, and it could go either way, whether they can charge interest on it or not, and whether we have that defense available. And usually that is left up to even whether we have the ability to do that in court. There's not necessarily a federal right of action, so it actually could only be done by the CFPB sometimes, some of these violations. So.
Last question. So then it falls off your credit at 7 years, whatever, but would this second, even though it's been charged off, like would a title search show that it's encumbered by 2 separate liens? I mean, so like it's so that's the thing. I'm like, okay, fine, the person that got the loans doesn't have it on their credit, but like if you were selling or you had something, there was there was a trust or there was some sort of inheritance thread, wouldn't a title search show that?
Right, but these homeowners aren't typically selling, so they're not causing a title search to be done. Just the homeowner straight up who gets a bill in the mail / couched in a foreclosure action. If they get that foreclosure action, which is the main example we're seeing at OFR, we're not seeing homeowners going to sell and saying, hey, there's a surprise second lien, because maybe if they have those resources and those attorneys, they can negotiate that or figure out what it is, kind of giving them the notice that we're trying to give them by proposing this bill. They're more likely just living in the house, sometimes elderly, and then get this second lien foreclosure.
Got it. All right. Well, thank you. This is more complicated than I thought initially, but all right. Okay. So thank you all very much. We'll bring up the next set of panelists. Ms. White, and it's Jeff Walsh, and I guess William, if you want to come on up, since I know you answered questions, but if you want to provide testimony.
Yeah, and I'm just gonna, hi, my name is William Steinwhittle. I'm the Deputy Advocacy Director for Homeownership Preservation at the Maryland Legal Aid Bureau, and I thank Delegate Jones and Senator Charles for allowing us to speak on this important issue. and the committee as well to speak on this important issue. So my written testimony has been submitted, but I'm going to just answer try to answer a few of the questions that were asked in additional detail of how this came about. The first is Senator Weston mentioned, you have if you have mortgages from two different banks, how exactly would you not know that you have two mortgages? Well, the problem is a lot of these mortgages were actually originated by the same bank, usually, or the same mortgage servicer. So basically what happened was, when a person went and got their mortgage back during the housing bubble, they would get a 20% mortgage for their down payment, and they would get an 80% mortgage for the actual principal and value of the property, and they would both be held by the same bank. So then when the property's values went down in 2007, when they redid the loan modification, they would get a loan modification from that bank, and then they, at the same time, would get a charge-off letter from the same bank saying that this loan was charged off. So you can obviously see how that would lead to a lot of confusion and how this would possibly happen. The second thing is, a lot of people during this era, so I'm also a bankruptcy attorney. I do, a legal aid is the only public service company that does legal services organizations that does Chapter 13s. We all, so a lot of the people during this time period who went to the private filed Chapter 7s, but the problem is that Chapter 7 discharges debts. It doesn't discharge liens. You have to file a Chapter 13 to strip off a lien if there's no value. So what happened is that they stopped receiving bills because they weren't personally liable on the debt anymore because they had filed a Chapter 7, but it was still on the property, and then the investors bought it, and then they proceeded with the foreclosure, but they hadn't received a mortgage statement for all those years. So I hope those additional points help the committee out, and I urge a strong report on the bill, and I'm here to answer any more questions that you have.
Chair, Vice Chair, members of the committee, good evening. My name is Marceline White. I'm the Executive Director of Economic Action Maryland Fund. Economic Action advances housing justice, equity, economic rights through research, education, direct service, and policy advocacy. We're here in strong support of Senate Bill 682. I will just touch on a few points from a policy perspective. As you heard, many homeowners had not heard from these out-of-state debt buyers for years, sometimes more than 10 years, and the debt buyers pursued these liens when there was enough equity in the house for it to be profitable for them to do so. You've heard that this is an issue in Maryland. You all have been working on homeownership and the housing crisis, as Chair Smith mentioned. Some of the reasons this legislation is important is because a foreclosure, as you all know, depresses the value of homes in a surrounding community. So this not only affects a homeowner, but those in the community where homeownership and the homes are foreclosed. In this current housing environment, it may be very difficult for an individual who loses their home to find a safe, secure, affordable alternative. And there may be an increased demand on state assistance when we can ill afford it if homeowners lose these homes. This provides transparency, so people have statements if someone is going to pursue the foreclosure after not having statements for 10, 20 years. It allows them to either come up with the money to stay in their home or to exit their home with dignity and with the time they need to do so. And again, on the business side, I have had debt. I got notices from my student loan borrowers. I've gotten notices from credit cards when I owe money, and we're just asking businesses to do the same thing, particularly before someone loses a home. So for all of these reasons, I am in strong support of Senate Bill 682 and urge a favorable report.
Hello, my name is Eric Orr. I'm a staff attorney with Community Legal Services, and I do foreclosure prevention. And most everything's been covered fairly well. I just wanted to clarify a few questions. And when these 80-20 loans were almost all the ones I've seen were initiated by the same bank, right? These were originated by the same group. They were 80-20 loans. The 20% second mortgages were for the down payment. These were borrowing for the down payment so they could get a home. And one of the things is that when the banks started to get When the financial crisis happened, the banks were forced by their regulators to actually clean up their books. And so they charged off anything that they thought would be that was worthless, just to make their books look a little better. And so that's why a lot of these places got charged off at that time. And these are loans that could never be made now. These are considered predatory, and it's just unfair to expect people to pay huge interest amounts on loans that were charged off, and they had no idea would still exist at this time. I think one of the, I just talked to a client yesterday, and he got his first notice in the mail was just a list, and it was just a list of every single month that he got, that a missed payment he made from when they didn't even own the loan, saying you didn't pay this for 11 years, and now you owe $95,000 in interest on a $50,000 loan. And he didn't even know exists. He's been paying his first mortgage the entire time. And we're just asking for a chance to provide Marylanders with a defense and a little equity in in this just horrible situation that they find themselves in.
So I was able to pull up a sample charge-off letter from financial institution or holder of a second mortgage, and who knows if this really is the model, but I imagine it might be. And it does, it includes the reason for the charge-off, repeated missed payments on your second mortgage, failure to respond to our attempts to contact you. And then it says important considerations. This charge-off will be reported to major credit bureaus, significantly impacting your credit score. Although the debt is considered charged off, you may still be liable for outstanding balance and could face potential legal action to collect the debt. So I guess, first of all, you are being told what's going on.
Absolutely.
But secondly, maybe that isn't enough. And I could see, rather than an elaborate bill, we might want to insist that clear language is put in these notices that aren't quite this vague, or figure some, or have these entities that have these have to work with some consumer protection organization like yourselves to make sure that you all can then send a more clarifying letter on this. So just a thought, but and respond. So you all obviously don't feel like this is sufficient notice, even though it is saying, I feel like it should have a definition what charged off means, because you know what Senator West and I thought was, okay, right. You got it off your books, and it's no longer legally enforceable. But that's not the case. Charged off means, in the parlance of financial institutions, we're not going to collect on it anymore. Right. No prohibition against selling it, and certainly the debt has not been satisfied. Right. And by the way, it doesn't even talk about how your interest would be, would cease, and if no notices continues to send. So I think it's a pretty lousy letter, and you could do a lot more with it. So your comments on that?
Well, I think one of the things is these charge-off letters are often 12, 13, 14 years in the past, and they came in concert with loan modifications from the same organization, right? So,
well, I don't know that to be the case for everyone. So, but if you're making the case that this applies in those circumstances, maybe the bill should say that. Go ahead.
Did you want to do this?
Yeah, I just wanted to add that there's nothing in this bill that is letting the person off the hook for the second mortgage.
I understand that.
And what we're just doing is that we're requiring them to provide some notice of that the debt still exists, so that myself and my organization's Community Legal Services can file notices of error to make sure that which is a document that you filed to mortgage companies to get some information, so that we know exactly what it is that they're trying to get back.
Well, this letter does inform them that the debt still exists. So I'm trying to suggest that this letter could be better written, but go ahead. So you're
Right.
You seem to imply they have no.
The problem
nobody
is
told them
most
this.
of these debts were so old that when they sent out the charge-off letter, they didn't, and then the other problem was that they don't remember they got the charge-off letter. The second thing is that after it was charged off, what the charge-off letter doesn't say is who bought it. So even if the person
Well,
wanted,
they may not know it this.
right? But if the person wanted to pay the loan, after it was charged off, it was bought by another organization. A lot of these organizations didn't send any notice when they got the original loan because it was still in the same situation at the time that they bought it.
When a loan like this is sold for pennies on the dollar, is there any legal obligation to notify the borrowers of the new owner of the debt?
No, not if they're not collecting. That's the difference. Now, see, that's why that's the whole zombie mortgage issue is that they sat and waited and waited and waited until their investment, which is that's why they bought the debt in the first place.
Right.
That's what it is. It's an investment until their investment paid off. And all we're asking is if they want to try to collect on their investment at this point, that they provide notice of what they're trying to collect on so that the person has time to retain counsel, find out information from the person that's trying to collect what the debt actually is, and try to come to some sort of resolution, either through a bankruptcy or through a loan modification for said debt.
And yes, I understand that. And you're suggesting that your process was 40. In the current process, what's the total number of days currently available? Let's see, it's 45 days to cure. And I don't know if there's any time lapse between the order to docket or if there's any time.
The earliest they can file is 45 days after the notice of intent to foreclose is sent.
I'm sorry, say that again.
The earliest that they can file the order to docket is 45 days after the notice of intent to foreclose.
Is that the typical practice, you think?
In the about 10 years ago, it was probably more of a gap. Now it's pretty close in time. I wouldn't say it's exactly 45 days, but it's probably pretty close to that.
And then when the order to docket, that's something that appears on in the case itself, right?
Judiciary case search. Basically, it's like filing any other. I mean, it's a different kind of complaint, but it appears like a legal complaint.
So when the order to docket is put in there, it's some kind of quasi complaint. Does the first, who does it go to, and what's your opportunity to respond to it?
So the order to docket is posted on the address of the property that's being foreclosed and is sent by certified mail to the address of the property is being foreclosed. It is not personally served because it's in rem action. Now, the one thing I do want to note is that Maryland's the foreclosure defenses, because we're a quasi-judicial foreclosure state, we're not a judicial foreclosure state, are limited. Basically, in a foreclosure, you don't have the right to discovery. You do have some rights to file a counterclaim, but they're limited. Basically, your main rights are three main rights. The first is you can file a motion to stay the foreclosure to stop any kind of sale. The second thing is that you can file a motion to dismiss if you believe the foreclosure is not based on the law and it is not permitted under the law. And the third thing is you can request a foreclosure mediation, as this body created in 2011, I believe. And you can request a mediation 25 days after the final loss mitigation affidavit is issued, as mailed to which is part of the order to docket procedure.
So this bill is going to be part of a work group on Thursday.
It is. You are so knowledgeable that
you are tapped already.
It's like an encyclopedia. I have a lot more other questions.
We've been burning this
stop
candle
now.
for a while.
All right, thanks.
So Senator West, understanding we are going to have more conversation with William here on Thursday if he will make himself available. I'll see
perfectly willing to make myself available.
That's great. That's music to our ears. Do you want to continue to burn the candle?
I just have one question. At the very end, on page 6, you say in an action to foreclose, mortgager may raise in defense of latches. Why do we have to put that in the bill? Isn't that a matter of law, that someone has a right to raise latches or statute of limitations?
Again, that is actually a matter of law, and we actually did discuss this
It sounds like it's gilding the lily to put it in the bill, too.
But apparently, but the one thing we wanted to point, and we did this, we're an LLC funded organization, so we don't lobby, but we did discuss this when the issue generally was brought to our attention by Delegate Jones. And the reason why they felt the need, and we kind of agreed with that this had to be in the bill, was because, again, the Maryland foreclosure law is very narrow, so a lot of judges are very hesitant to make it a knocked out, dragged out litigation. So they felt that this was a direction for the judiciary that they could, in these specific circumstances, these zombie mortgage circumstances, they could open the door a little wider to the defense of latches. But yes, it is a defense that exists. It's just in foreclosure cases, they tend to be very narrow about the litigation they will permit.
Okay, thanks very much.
Excellent. All right.
I just wanted to make, I'm sorry. The latches thing was specifically something that the Court of Appeals said is not available as an argument anymore as of last year. And so because there is no statute of limitations, obviously latches shouldn't apply. And therefore,
The fate of the bill is slipping every second.
Sorry.
Every second.
I apologize.
All right. They were all going to be too tired of this bill to work on it anymore if there's any more. All right.
Just pass it.
Or just draw it. But so we're going to have something on Thursday. Okay, thank you very much. All right, we're going to move on to Mr. Walsh, who is joining us virtually. Mr. Walsh, you're up. Welcome.
Hi, good afternoon. My name is Jeff Walsh, and I'm a senior attorney with the National Consumer Law Center. And thank you very much for the opportunity to make a few comments in support of Senate Bill 682. We believe that this bill is very helpful because it authorizes a 24-month pause in the foreclosure of what are designated as materially delinquent mortgages. And this pause creates a framework where parties can restart communications, communications that really should have been in place and ongoing under federal law for many years and even decades. And the bill can avoid the unfortunate situation where a lender that has really flaunted federal laws that required ongoing communication for many years could simply foreclose without being held at all accountable for not complying with those federal laws. And we've suggested a few proposed amendments that somewhat go to this issue of laches that was just brought up. And I think that the provision on authorizing the laches defense in foreclosure cases is important, particularly if you look at the similar Virginia bill, the Virginia H. Bill 184, that ties a foreclosure defense explicitly to whether prior notices were given when the lender is claiming interest in a foreclosure case. And I think if this bill were tweaked a little more in the nature of the Virginia bill, it would be clearer that borrowers would not be put in the position of facing this mounting amount of accrued interest. Thank you.
All right, thank you very much, Mr. Walsh. Seeing no questions, that'll conclude the testimony for the proponents of the bill. Thank you very much for hanging in there with us. We'll now move on to the opponents of the bill. We'll hear from Mr. Enton, and then we'll hear from Scott and Jeffrey Nadell, who are both joining us virtually. Mr. Enton, I would apologize for making you wait so long, but you're getting paid more than anyone else here to sit here this afternoon, so welcome. All right.
If only it were so. Thank you very much. Robert Enton on behalf of the Maryland Bankers Association and the Coalition of Maryland Lending Service Attorneys that handle foreclosures. And we're very, very strongly opposed to this bill. I urge you to please read the bill, okay? The bill has provisions in it that to me are just quite remarkable. Provisions that say that you have to give a notice and if you haven't been, if your loan hasn't been paid, and it's been 5 years since the person received a bill, then if I'm the holder of a second mortgage, and that's what mostly concerns me, is that very often, if you're going to buy a house, you're going to have to come up with, say, maybe a 20 or 30% amount of money at closing, and the holder of the first mortgage is going to loan you, say, 70%. Now, where are you going to get that other money? Very often you get it from someone that makes a second mortgage. And with this, and you're not going to get paid, and you're not going to be able to enforce that second mortgage as long as that first lien is there. So what you see is you see the holder of the second mortgage who waits, and I'm going to run out of time, who waits until the first mortgage has been paid, and then they go to enforce it. This says that if you tried to do that, you would, and if you hadn't sent a notice every month for some period of years, and here it's 5 years, then before you can attempt to foreclose on the mortgage, you would have to go and send notices every month for 24 months. Now, that's one problem. If I could, Mr. Chairman, let me just point to some of the other provisions in the bill that are so disconcerting. It says that the court may order any relief the court considers to be appropriate. I'll go on and on, but I will meet with all of you to talk about it.
Yes, I appreciate that. Senator West has a question.
Did you want to give us one more reason why this bill should be?
You know, I just think that it's if you look at the testimony from the Commissioner of Financial Regulation, he says that fewer than 1% of Maryland mortgages fall into this category. Fewer than 1%. Yet we have this bill in front of us, and which is somehow assumes that everybody that wants to try to enforce a second mortgage and hasn't sent a bill every month is somehow evil. But what choice do you have? What choice do you have? Latches. Where do we see a bill anywhere in Maryland that says that latches are latches and it's common law? I just really think that this bill is way over the top. If, in fact, you haven't exercised your rights under your mortgage, then for some period of years, and you wanted to have a bill that says right now you can't send a notice of intent to foreclose until the loan has been in default for 120 days. And then you send a notice of intent to foreclose, and you have to wait at least 45 days before you can file. And then you have pre-filing mediation, post-filing mediation. You can have a hearing. All these protections right now in the state of Maryland, if we have 10,000 notices of intent to foreclose that go out in a year, last year we had a total of 1,772 mortgages in the entire state that went to sale. Why? Because we have a remarkably robust and thorough foreclosure process. I would not object, Senator West, if you wanted to have a bill that said if you haven't sent a monthly bill out, then rather than having to wait 120 days, you had to wait 180 days. I mean, to put some reasonable provisions in this, but I wouldn't have made that loan and you wouldn't have made that loan on an unsecured basis. And just because, you have, the holder of the first mortgage said, I'm walking away, that doesn't mean the holder of the second mortgage that loaned the money and only loaned it because it was secured by the house shouldn't have a reasonable right to try to collect their money. So that's why we're so, strongly opposed to the bill. Sorry to ramble.
No, that was good.
But I am worked up about it.
Appreciate it. No, it's good. Are there further questions from Senator James?
Bob, the hour is late, and I think everyone wants to end the day, so you could follow up with me. But, that's what you're talking about was driving some of my questions, this 2 years, 24 months, very elaborate process and a lot of language. So, but I do sympathize with the sponsor that there is probably even that 1% of zombie mortgages, an even smaller percentage of where the that's been bought for pennies on the dollars. People wait. And then, it is kind of a surprise. And it is, for the homeowner, just, can be overwhelming, not for you and me, but there's people, this is overwhelming. So after the bill hearing, if you want to get back to me, any language that you think we could pass to improve the situation modestly about getting this on people's radar and making sure they're not surprised without this elaborate process. I do think the letter's a little lacking, the letter of notice could be altered and be more clear, and maybe some other modest things that would get at that very, very, very small group of people for which this is quite a sharp practice and quite a stunning
I have no problem with that whatsoever, Senator. I mean, trust me, and it's interesting, the Commissioner of Financial Regulation convened a work group during the summer to deal with this. We had one meeting, we never had another one. There were lots of people on the call, consumer advocates, foreclosure lawyers, but I've never been opposed, and I wasn't opposed then, to trying to deal with the situation, but to deal with it in a reasonable manner.
Right, I agree. All right, thank you.
Thank you very much.
All right, well, the hearing that won't end, we've got another, actually, there's Scott, you're in, we got you. Is Jeffrey in as well, or just Scott today? All right, this is the last one, yeah, so here you go.
I think it's just gonna be me.
Okay, excellent. We're having a little bit of trouble hearing. Can you, the volume's a little low.
Is that a little better?
There you go. Yes, much better. Welcome.
Well, thank you for having me. I know that the hour is late. My name is Scott Nadell. I've appeared before you before. I'm happy to be here again. I just wanted to reiterate, Senator James, what your comment regarding the charge-off letters. The borrowers are notified that there may be an instance at a later time that this matter may come back to them. This isn't a shock. They knew about it. While there may be unfortunate circumstances that surround it, the loan didn't go away. The loan was there, and the lien remains. The loan may have been discharged into bankruptcy, but that lien remains. And the fact of the matter is that we do have protections right now. We do have a mediation program. We do have a notice of intent to foreclose. We do have a lot of things that borrowers can avail themselves of to try and avoid foreclosure. There are also issues of presentment on a lot of these notes that also waive the issues of presentment of notices. So borrowers have, in large measure, already waived those notices. But to the extent that a loan has been charged off, they're now made aware of it. They know about it. They know that it could come back to them. And once again, while it can be unfortunate, we do have robust avenues for borrowers to go through. If they don't like what happens at a mediation, which they can go to, and they sit down with the lender, they sit down with the representative of the lender, they can then file a motion to stay or dismiss, which is heard by a circuit court judge in the county where the property is located, and that gets adjudicated. So this isn't something that takes 5 seconds and there's a foreclosure. There's a 45-day letter, there's the posting of the property time, there's a mediation, there's a preliminary loss mitigation affidavit, there's a final loss mitigation affidavit. You have to certify to the court what avenues have been taken to try to mitigate this loss. So that it's not as though there's nothing there. There are robust proceedings. Thank you.
Excellent. All right, seeing no further questions, thank you very much. Thank you for hanging in there with us.
Thank you
All
for
right,
having me.
excellent, thank you. With that, that'll end the hearing for Senate Bill 682 and our hearings for the evening. See you all tomorrow.